All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-3051. United States of America versus Luz Irene Fajardo Campos, also known as La Comadre, also known as Jenny Campos, also known as Jenny Aviles, also known as Janka, appellant. Mr. Axum for the appellant, Ms. Lloyd for the appellate.
Good morning, counsel. Mr. Axum, please proceed when you're ready.
May it please the court, counsel. Tony Axum representing the appellant Luz Fajardo Campos, and I'd like to reserve 3 minutes for rebuttal. There was no venue in Washington, D.C. Under the Constitution, venue shall be laid where the crime was committed. And where a crime is not committed in any state, Congress can choose where to set the location for venue. The charged conspiracy was committed in Arizona and Mississippi. Law enforcement seized drugs there and arrested alleged co-conspirators there.
The offense was the agreement. These are conspiracy counts. What evidence is there that the conspiracy was hatched in Arizona?
I'm not sure that the government presented evidence that the conspiracy was hatched in Arizona, but
these are conspiracy counts. Only thing that matters is where the agreement took place.
I think under the Constitution, the Constitution requires that venue be laid where the crime was committed, not
where the crime was committed. Crime is the agreement.
Well, we know that it was not committed in Washington, D.C. So the Constitution also says where the crime is not committed in any state, Congress can set the location for venue. So we know that the crime was not committed in Washington, D.C. Therefore, there's no authority to set venue in Washington, D.C.
But it wasn't committed in the United States, right?
It absolutely was committed in the United States.
The
It was
agreement?
Well, if we're talking about the formation of the agreement, I'm not sure that the government presented evidence as to where the formation of the agreement took place. There's certainly evidence that it did take place in Mexico. There's certainly evidence that it did take place in Arizona and Mississippi. But
well, let's suppose, can I ask you this? Let's suppose that the agreement took place outside the United States. Then does Congress not have the authority to specify that venue can lay in the District of Columbia? For a conspiracy offense where the agreement was reached abroad?
certainly if all parts of the conspiracy took place abroad. But there are two phrases in the Constitution. One is where Congress should set, where venue must be set when a crime is committed here. And when a crime is not committed here, the Constitution says, but when the crime is not committed within any state, we know that this crime, this conspiracy, and a conspiracy is a continuing offense. I mean, the government benefits from that all the time because they are allowed to establish venue in any location where the conspiracy was committed. The government runs away from that now because the conspiracy was committed in Arizona and Mississippi. But under the Constitution, but when the Constitution says, but when the crime is not committed within any state, the trial shall be at such place or places as Congress can set. The plain text of the Constitution does not allow Congress to set venue wherever it wishes if the crime was committed in any state. We know that this conspiracy was committed in Arizona and Mississippi. I understand.
I know object offenses occurred in those states. That seems different from the question whether the conspiracy itself happened there. I mean, yeah, it's a continuing offense in the sense that any crimes committed pursuant to the conspiracy can be attributed to the conspirators. But I mean, the agreement itself, it's an on-off switch. There's a conspiracy, it's formed, that's an offense. And it continues unless and until someone separately withdraws from the conspiracy, which isn't alleged here.
Yes. And then I think the question is, where was that conspiracy committed? The question is not where was that conspiracy formed? Where was the agreement reached? Where is the first place that the elements are satisfied? Because it's continuing, and again, that is why the government benefits from charging someone where there, for example, in Sitzman, where there is a single phone call to, let's say, Washington, D.C., that would establish that the conspiracy was committed in Washington, D.C. So the Constitution's asking, like, is asking where was the crime committed, not where were the elements satisfied, where is the first place that an act in a continuing offense took place. I'm not sure that I'm not aware of any elements test for establishing venue.
And suppose there had never been any drugs imported. They just proved there was a conspiracy in Mexico to import drugs, and thankfully it was stopped before the drugs crossed the border. And that would be prosecutable as a conspiracy, and for which venue could be assigned to the district.
Absolutely. If we know that the entire offense took place, if we know that the offense was not committed within any state, absolutely, the Congress can set venue wherever it wishes because the Constitution allows it. That's exactly what the Constitution says. If that is the only evidence, but that wasn't the only evidence in this case. The government did not have to join the Arizona and Mississippi counts in this case. It chose to do that. So by doing that, the government bound itself to the limitations of the Constitution. If there are no other questions on venue, I'm happy to move on.
Just one quickly, which is, what is the good cause for not having raised this pretrial, which I think you have to have done? You have to raise pretrial unless there's good cause.
I'd respectfully disagree that we have to show good cause at this point. Under Rule 12, a defendant can file a motion and should file a motion to dismiss where venue. Rule 12 does say must, but we're not at this point alleging that there was a defect in the indictment and asking to dismiss the indictment. We're proceeding under Rule 29, and venue is unique within Rule 12 as to because venue is actually the only, I guess, issue, objection, or challenge that is actually a question of sufficiency. So under Rule 29, we are allowed to challenge venue as an element at the close of government's case without having raised it as a pretrial question under Rule 12.
You raised it at the close of the evidence for the first time?
Venue was not raised at all.
When was the first time you raised it?
The first time is in this appeal, in this court. That's correct. So
there was a general motion for acquittal, but not a specific objection as to venue.
That's correct. And as this court is aware, a general motion for judgment of acquittal preserves all elements of the offense, and venue is an element of the offense. So we are in the position that we can challenge it and we should challenge it. And the only question is whether it was essential or not, whether there was any evidence of venue in Washington, D.C. I don't think the government disputes that. This is again, venue is unique in itself under Rule 12, but this is an unusual case in that the government presented absolutely no evidence of venue in Washington, D.C. In most cases, there is a question.
Venue is an element?
Yes,
You have to prove that to the jury?
yes. I mean, yes. I mean, it's an element that's proven by preponderance. I mean, the jury is instructed, but and it is an element, yes. I mean, it's not something that the government can ignore.
Element provable by a preponderance? Sounds odd to me, but okay.
That's what the Supreme Court,
Okay.
it's odd to us too. We would prefer that it be beyond a reasonable doubt, but
Okay.
that's the standard that the Supreme Court has set. But this court and the Supreme Court have clearly stated, United States v. Hare, that venue is an element of the offense that the government has to prove. So in the absence of any proof, the remedy is reversal. I'd like to turn to the ineffectiveness claim if there are no other questions on venue. Counsel was ineffective in failing to request a multiple conspiracies jury instruction. The evidence clearly supported one, and the district court would have been required to give it. There was no conceivable strategic reason for counsel's failure. Ms. Fajardo Campos's defense, as counsel presented it, was a reasonable doubt defense. Thus, the multiple conspiracy instruction would not have required an admission of guilt, as the government argues. And even if there were some inconsistency, counsel could have requested the instruction, and the jury would have been aware of its obligation to decide whether a single conspiracy had been proven or whether multiple conspiracies had been proven. And counsel did not also have an obligation to argue it. Defense attorneys ask for instructions all the time and do not argue those specific instructions. So there was no strategic reason, conceivable strategic reason for counsel's deficiency in failing to request the instruction.
You also raised a substantive claim about single conspiracy and multiple conspiracy, right? Not just with an ineffectiveness overlay.
Yes, but I would say that the two arguments are distinct because prejudice under an ineffectiveness claim asks whether there's a reasonable probability of a different outcome rather than simply whether the evidence was sufficient. And my substantive multiple conspiracy argument is essentially a sufficiency argument. Whether counsel should have requested this, should have requested the instruction, establishes counsel's failure to request the instruction.
Well, can you prevail on the ineffectiveness claim if you don't prevail on and I know you'll resist the assumption, but just for purposes of understanding how these arguments fit together, if you happen not to prevail on the substantive claim, can you nonetheless prevail on the ineffectiveness claim, even though the substantive claim as to which the instruction ostensibly should have been sought would have lost in court on that assumption? Yes, because again, the standard, and I understand that the standard is uncomfortable. I think Noye even points out that it's an unfamiliar standard for courts to apply because it's speculative. And the standard
for the ineffectiveness claim is whether there's a reasonable probability that any juror would have had a reasonable doubt as to whether the government proved single conspiracies or multiple conspiracies. And a reasonable probability is not even a preponderance. It doesn't ask whether the defendant was prejudiced as the substantive multiple conspiracy argument claim requires. It only asks whether at least one juror would have had a reasonable doubt as to whether the government proved the single or the multiple, whether there was actually a rim connecting the multiple conspiracies, whether a single juror would have had a reasonable doubt as to whether there was a rim connecting the multiple conspiracies. I think once we've established that there are multiple conspiracies based on the record evidence, it's inescapable that a juror would have had a doubt as to whether the government proved the single or proved the multiple. I think a jury instruction, and one example is the jury instruction in Tarantino that this court approved, simply asks that very question, whether the government proved a single conspiracy or multiple conspiracies. If the answer is yes, you don't move on to the second stage of whether the defendant was prejudiced, whether the evidence was sufficient, whether there was a more narrow conspiracy than the broader overarching conspiracy charged. And again, the government benefits from being able to charge multiple conspiracies in a single count. And it benefits because it can prove in the alternative, it can prove a more narrow, but there are consequences that go with that benefit. One of the consequences is that jurors should be instructed as to whether these multiple acts constitute a single conspiracy or whether they constitute multiple. The government didn't seek that. I understand defense counsel didn't seek that. My argument is that was ineffective. And this difficulty like in understanding like multiple versus single conspiracies is very fact intensive. That's why this court has historically deferred to the jury's findings on multiple or single conspiracies, because it is traditionally the jury's province to decide that.
This issue, sorry,
Yeah.
are you finished?
When counsel fails to ask for that instruction for something that's so essential and so clearly like the province of a jury, the defendant has been prejudiced.
This seems to all flow from your argument about material variance, right? The multiple conspiracy point. And I'm just having a hard time understanding that, because the indictment is written in pretty broad terms, right? It's a conspiracy, it references conspiracy, the defendant together with others, doesn't say who, just anyone else. It says a conspiracy to distribute cocaine and methamphetamine. Doesn't have a lot of additional detail about with whom, when, which flights, right? And all of the subsidiary conspiracies that you're positing the jury might have found, I mean, any one of them fits within the general parameters of the indictment. And you haven't argued, I think, you haven't argued that the indictment was too vague to give you sufficient sense of what the trial was going to be about. So how can there be a material variance?
Well, if we're going to stick to the strict language of the indictment, the indictment does charge a single conspiracy. And that conspiracy is not simply to distribute cocaine, and not simply to distribute methamphetamine, and not simply to manufacture methamphetamine. It is for all those three things, all three of those, like what I would say separate conspiracies, all with the intent to import the cocaine or the methamphetamine into the United States. We know that that most of these conspiracies for cocaine have no mention whatsoever of the United States. And the government has to prove actual knowledge and intent to import into the United States, not constructive, not just because I'm producing in Mexico and United States buys cocaine that there's an inference that it's headed to.
If the government proved all of the elements with respect to cocaine, but not with respect to meth, that would be sufficient to support a conviction under the terms of this indictment, right?
Well, my argument is that it's not, but
I mean, the and really is an or. Conspiracy to import cocaine and meth. They prove cocaine, they get a conviction.
The problem is that the first question is whether it's a single conspiracy or multiple conspiracies. If your conspiracy is to import into the United States, and one of the two conspiracies does not involve importation into the United States, there's a conflict between those conspiracies. You by definition, have two conspiracies, one to do something in Mexico and the other to do something that impacts the United States. I also point out that the venue...
But the verdict form and the jury instructions required proof of all of those elements, importation. The only thing the verdict form did differently from the indictment was to separate the cocaine aspect of the case from the meth aspect, and the jury convicted on both.
Well, I'd respectfully disagree that the verdict form is the same as a jury instruction. I understand that
Sorry, same as the indictment. It just breaks the cocaine issue apart from the meth issue. And the jury convicts on both. So what difference?
The verdict form asks the jury to determine the quantity that the defendant is responsible for.
Right.
If that's the only place at which anything is broken apart, that there's any distinction made between cocaine or methamphetamine. And that quantity finding is not a finding that there is a single conspiracy. To decide whether the government proved the elements of the offense, you have to back up to the actual instruction. And the actual instructions combine cocaine and methamphetamine at every step. They don't make a distinction at all. So the jury was never instructed that there is evidence of multiple conspiracies. There are conspiracies within conspiracies. Conspiracy, as this court has said, in a hub and spoke conspiracy, where you don't have integrated actors all working interdependently with one another. For example, a typical drug conspiracy would have a source who's supplying to someone who is distributing, and the distributor is then supplying to someone who's wholesaling, and the wholesaler is then supplying to someone on the street. The government didn't present any evidence of an integrated chain like that whatsoever. The government presented text messages and chats spanning 2.5 years and conversations that span 6 years. Every conversation that Luis Fajardo Campos had with someone where drugs was mentioned. We're not arguing that Luis Fajardo Campos did not engage in drug trafficking. I'm arguing that she should have been found guilty of the conspiracy in which she participated. and there was not an overarching conspiracy to distribute cocaine, methamphetamine, and to manufacture. It's not just distribute cocaine and distribute methamphetamine and to manufacture methamphetamine, all with the intent to import to the US. The government simply didn't establish one conspiracy.
Suppose I disagree with you on, I'll just call them the really micro conspiracies, conspiracy with this guy to secure these flights to that city. I don't want to break it down that finely, but I am interested in the issues we're discussing.
Yes.
On the one point about whether the cocaine conspiracy is linked to the meth conspiracy. So help me out with that. I had thought that the verdict form solves that problem because the jury checks yes and makes up an amount finding. Says yes to cocaine, yes to meth. So it doesn't really matter whether you think of them as one overarching or two separate. Help me with that. You're saying the jury instructions don't break it up?
No, the government won't provide you any jury instructions with regard to the verdict form. Because there aren't any. It says read the verdict. They essentially say read the verdict form and decide what quantity the defendant is responsible for. That's not a finding of guilt. I mean, I can't say that it's not a finding of guilt at all, but the guilt determination has already been made based on other instructions that do not separate out. So the judge says, do not look at the verdict form until after you have decided guilt. So I understand. And the government has to do the quantity findings because I think it's Eileen requires when you're seeking a mandatory minimum that the jury find the quantity that is the mandatory minimum. That verdict form was not designed and does not accomplish the task of separating one conspiracy for another and asking the jury to make a determination whether a single or multiple conspiracies were proven.
And why, last question on this line, why does any of that matter if the quantity finding for either cocaine or meth by itself is enough to just go almost off the charts on the guidelines? And this is a case where there's a very substantial downward variance. So what are we arguing over? You get guilt as to both, and
well, if
the amount of meth by itself is more than enough to support a sentence well above the one that was given.
I think if the court, if you're looking at simply the jury findings of the mandatory minimum, I disagree that those quantities take the guidelines off the chart because the quantity that the jury found was 4.5 was, I think it's 5 kilograms.
5 kilograms or more of cocaine, 500 grams or more of meth.
500 grams or more of meth.
Pretty high number.
Well, 500 grams or more of meth is offense level 38, and 5 kilograms of cocaine is 28. The sentencing guideline chart goes to 38.
22 years?
Correct.
Which corresponds to what? Would correspond to what offense level? Something a lot lower, I assume.
22 years corresponds to offense level 39. So okay. There's a significant difference. If we're talking about sentencing as to the specific findings of, I mean, that's 262 to, if my math is correct, 22 years times.
Well, I'll check it. I got it.
So
If my colleagues don't have additional questions, then we'll give you the time for rebuttal, but I want to make sure you do.
thank you.
Thank you, Mr. Acker. Lloyd?
Good morning, Your Honors. May it please the court, Alea Lloyd for the United States. Turning first to the venue challenge, the defendant's venue challenge was untimely and meritless. The defendant has not shown good cause, and even on plain error review has not satisfied her burden of showing that the district court plainly erred in allowing venue to occur in the District of Columbia. Starting first with the untimeliness of the challenge, numerous courts in the plain language of Rule 12b3 requires for a defendant to bring a venue challenge when the basis of that challenge is reasonably available to the defendant pretrial. And that's exactly what happened in this particular case. The defendant alleges that there's no tie to venue in the District of Columbia, and those allegations were not in the indictment. The indictment does not allege that the conspiracy was entered into in the District of Columbia, that overt acts occurred in the District of Columbia, that the defendant was arrested or first brought in the district from abroad, or that any acts occurred in the District of Columbia or any facts that would support venue under other statutes. So that's an obvious alleged defect in the indictment, which brings this under the Rule 12b3 rules. Under those rules, Rule 12 requires good cause to consider an untimely venue objection, which the defendant has not provided. So for those reasons, we think that the defendant's challenge.
Let's just suppose that it's under plain error instead of good cause. I understand and take your argument. But if we get to plain error, then I'd like to hear your response to the.
Yes, Your Honor.
I heard about the constitutional provision.
If we get to plain error, the defendant has not supported her burden of showing that the district court plainly erred. The defendant points to no cases where any of persuasive or binding authority where a court has held that a conspiracy under 963, where the defendant has committed all of her acts and entered into the agreement abroad, cannot be brought under the provisions of 3238 or 959C. And in fact, the government has pointed in its brief to 5 cases that hold otherwise. So the defendant has not met her burden of showing that there was a plainly erroneous decision by the district court. And we cited those cases on page 25.
There's definitely case law, but just in terms of the language of the constitutional provision, the argument that we've heard is that conspiracies it's true that the agreement might have occurred somewhere else, but the conspiracy is a continuing offense. And so if aspects subsequently occur here in a particular district, then it's not a situation in which the offense wasn't committed in any district, because at least if the offense is a continuing one, then some of the offense was continued in some district here, and you have to bring the prosecution in one of those districts in that event. That it could have been brought just as a claim that involved an agreement full stop, and that there was nothing introduced about where the continuing offense then was carried out. But this case is different because here there's a focus on Arizona, and there's focus on 2 states where the continuing offense continued to occur.
Well, Your Honor, first I would point, Your Honor, to the indictment, which did not allege any overt acts or that the conspiracy took place, although it did say it took place in the United States. It didn't say that it took place in Arizona or Mississippi or anywhere else. But secondly, I would also point, Your Honor, to the Supreme Court's decision in Whitfield, which says that for a conspiracy prosecution under the common law rule, the district in which the unlawful agreement was reached would satisfy the default venue rule. And here there's been then all of the evidence submitted by the government show that the unlawful agreement by this defendant was reached abroad, which then calls into play the constitutional stricture that the Congress can then direct where venue may be held. And that is the 2 statutes that we've cited, 3238 as well as 959C. And the 2 of the courts in particular, Levy Auto Parts in the 4th Circuit and Miller in the 2nd Circuit, explicitly discussed the requirements of Article 3, Section 2 when deciding that under 3238, when a conspiracy is essentially foreign, even where some of our acts or offense conduct occur in the United States, venue is still proper under 3238. And of course, the venue was proper in this particular case under 3238 because the defendant who committed and begun her offense abroad had no last known residence in the United States and was indicted before being first brought or arrested to the United States. So we think clearly that the Constitution's requirements were satisfied. And of course, under plain error review, the defendant is not pointed to any case that would hold to the contrary. The 2 cases that the defendant cited, Kobar actually is in our favor. One defendant who acted in the US, the court held there was no venue for, but the other defendant who acted extraterritorially, like our defendant, venue was found to be proper under 3238. but that a defendant was not first arrested or brought in DC, and so 3238 couldn't apply. That's not the case here where it does. And then Gilboa, which the defendant also cites, was held by Miller in the Second Circuit to be dicta. And so the Second Circuit holds that 3238 is allowed to provide for Brenu when certain offense conduct occurs in the US, so long as the conspiracy of the offense is essentially foreign, which is exactly the facts we have in our case today. I just wanted to address the idea that I think the defendant said that, no, I think that's all my thoughts on venue, Your Honors.
And we've got the single and multiple conspiracy questions.
Yes, happy to turn
So
to,
just one quick question. The indictment alleges that the conspiracy happened in Colombia, Mexico, Ecuador, Panama, the US, and elsewhere.
that's correct.
That wouldn't, you could sustain a conviction even if there were no acts in the US. And this is a charge about importing, so you would expect you need extraterritorial acts. You don't need acts inside the US.
That's actually absolutely correct, although the government does take the position that there were overt acts shown
Right.
in this case to be in the US. 963 under most case law, including this court, does not require an overt act for proof of the conspiracy or to be charged. And there were no overt acts charged in this indictment either.
So I guess, I mean, if you think of conspiracy as continuing in the way that the chief judge was suggesting, the indictment wouldn't really signal one way or the other whether the crime charged occurs in any state.
That's correct.
You wouldn't know.
That's correct, which is why we think that this had to be a challenge brought to under 12b3 pre-trial because there's an alleged defect that's obvious. And so the defendant had the basis for the
Oh, I guess
argument.
I was going the other way with that, which is it could be perfectly valid to convict based on extraterritorial acts. And if it was purely extraterritorial, venue would lie in DC.
Yes.
But on your opponent's theory, that depends on whether or not there were overt acts in the US.
Well, Your Honor, we don't believe that the overt acts are necessary to the conspiracy charge, which is what Whitfield and the Supreme Court held for why venue would be proper where the agreement is reached.
Okay.
And as I also said, the other circuits have not yet decided or have decided that even if overt acts occur in the United States, so long as the conspiracy is essentially foreign, i.e. formed abroad, then 3238 applies even under the Constitution. And under plain error rule, which is what we're operating under, the plain error review standard, we don't think that the district court plainly erred in following the weight of the circuits.
Okay.
Turning to the variance issue, I just want to emphasize that the standard for this is in the light most favorable to the government, drawing all reasonable inferences in its favor. And under that standard, the evidence clearly showed a single overarching conspiracy. The defendant, known as LaDonna and the Godmother, titles given only to persons of status in a drug trafficking organization, oversaw the manufacturing and transportation of vast quantities of narcotics that were imported into the United States and elsewhere and distributed for profit. And the members of her organization, her children and other participants, knew or must have known that others known and unknown to them were sharing in this large project, even if they didn't know who those people were or the parts that they played. Instead, the defendant is just pulling pieces of evidence piecemeal and in isolation when we need to look at the broader context and all the evidence that was admitted. So under this court's precedent, there are three main factors that we need to look at to see if there was a single overarching conspiracy. Those are a common goal, interdependence, and overlap. And the evidence showed that all three of those factors were met in this particular case. Just giving some brief highlights of the evidence for each factor. The common goal was profiting from importing narcotics into the United States and elsewhere. Evidence showed that the defendant was the leader of a drug trafficking organization whose goal was to traffic cocaine and meth into Mexico and then out to the United States and other countries. There was testimony that the defendant sent her drugs to the United States and had distribution offices in multiple United States cities. And so all persons utilizing the defendant's distribution network shared in the same purpose. They all were trying to profit from the importation and distribution of narcotics. In terms of interdependence, there was overwhelming evidence that this was a single conspiracy. The main structure with the defendant at the head of it, with her children operating beneath her, with the defendant setting prices, authorizing the use of pilots and aircraft, organizing the transportation. Her children were acquiring customers and helping with the distribution. But this was a large-scale operation. This defendant was trafficking amounts of 250 kilograms of cocaine, vast amounts of precursor chemicals to make meth, stamping cocaine with her name on it as a brand. And there were repeated agreements with multiple other conspirators to distribute wholesale quantities of narcotics for distribution. In terms of the evidence for the United States distribution, there were multiple text messages where the defendant, in her own words, or other conspirators mentioned that the drugs were going to be heading to the United States. I point the court to the record in 1553 to 54, where the defendant and her daughter are discussing securing a charter to transport 500 kilograms of cocaine heading to the United States. Another at 1554 through 1555, where the defendant and her son Paco are discussing a cocaine load that's being sent to the United States. The fact that the meth that the defendant was discussing with her son Activo was seized in Jackson, Mississippi. But nonetheless, there are other record sites, which we put in our brief, that show that other conspirators also asked the defendant or knew that the defendant was sending her drugs, including the cocaine and meth, to the United States.
And what's your best evidence? I think you're right. There's plenty of evidence of a large cocaine conspiracy, and same for the meth conspiracy. One of them, cocaine, you've got all the flights from Colombia to Mexico. Meth, you have the lab she's running in Mexico. What's the evidence that this is one conspiracy rather than two, right? There's a cocaine ring and there's a meth ring, and why are they the same?
Your Honor, that's our overlap factor. And that particular factor is supported by the fact that not only did the defendant participate in both schemes for meth and cocaine, but also her main collaborators, her children, participated in both schemes, the meth and cocaine. And so from that understanding, which I think the court held in Mathis, there's clearly overlap in an overarching conspiracy when the main figures are participating in both schemes. That's clearly satisfied by this particular case, with the sites that I already cited to you earlier about the defendant discussing with her children both cocaine distribution and transportation and meth distribution and manufacturing and transportation. So that's our best evidence, Your Honor.
And all we need to find is legally sufficient evidence.
Yes, Your Honor. But even
So
if Your Honor,
is it basically a sufficiency claim? So it's if any rational juror could have found that there's the overlap you indicated so as to support the jury's determination that there was a conspiracy.
yes, Your Honor. It's a sufficiency claim, any rational juror, with all evidence being viewed in the light most favorable to the government.
That's one way in which you could win.
Yes, Your Honor.
Could you also win based on the verdict form and the fact that the jury checks yes to both boxes?
Yes, Your Honor.
Or did we run into problems with the instructions, as your friend was suggesting?
Absolutely not, Your Honor. As you've already mentioned, we were allowed to prove in the conjunctive with and, or charge in the conjunctive with and, but prove in the disjunctive.
Right.
And so the fact that the jury found both cocaine and meth is enough for us to sustain a verdict. But also, whether they charged, if they found it together or separate, it doesn't matter. But more importantly, turning towards the jury instructions, the government believes that the instructions actually did inform the jury that they could prove or find a guilty verdict for cocaine or meth or both.
As to where you're looking.
Yes, Your Honor. If you look at 3, the district court instructs the jury that.
Which volume of the?
That would be volume 7. So 1653, the court instructs, and I'm cutting off a bit of the quote, but all 12 of you must unanimously agree,
Where are you on the page? Oh, I see.
Oh.
I have it.
No worries. All 12 of you must unanimously agree that Ms. Fajardo Campos conspired to distribute the same controlled substance or substances for importation into the United States. A little bit further down, when the court instructs on the verdict form, the court also instructs, if you determine that the government, this is, 1723 through 24, also in volume 7. If you determine that the government has proven beyond a reasonable doubt that Ms. Fajardo Campos conspired to distribute a quantity of cocaine and/or manufacture or distribute a quantity of meth for importation into the United States, you must indicate on her guilt on the verdict form and then make a determination as to the quantity of the controlled substances for which Ms. Fajardo is responsible. Your determination of those quantities, and this is me paraphrasing on 1725, must be unanimous. And you must be satisfied that the United States has proven those quantities of cocaine and meth beyond a reasonable doubt. So the jury was clearly instructed that they could prove on one, both, or the other. And I don't think there's any doubt once you look at the verdict form that they checked the box for both and found for both in the quantities that we needed and charged in the
So
indictment.
conspiracy on sub A or count A. Conspiracy is shorthand for all elements of the conspiracy offense explained in the jury verdict.
That's correct, Your Honor. And that's, I think, as you review 1653, which is the instructions on the substantive count versus the instructions at 1723 through 25, explaining the verdict form, those dovetail nicely in showing you have to find an overarching conspiracy. It can be for one of the drugs, both of the drugs, or the drugs separately. And then how you indicate that is the instructions for the verdict form. So I think the jury was well instructed and clearly found the evidence supported the indictment charges and marked that on their verdict form. And finally, Your Honor, just turning briefly to the point on the guidelines. For the ineffective assistance of counsel claim, I'll turn to that one next. We believe that the record conclusively shows that counsel's performance was not deficient. The Strickland standard is highly deferential, and there's a strong presumption that counsel's actions were reasonable. And that's particularly true in this circumstance. One, it was reasonable not to ask for a multiple conspiracies instruction because the overwhelming evidence showed that the defendant was the leader of this overarching conspiracy. But two, as the Seventh Circuit pointed out in Driver, the defense counsel could have reasonably concluded that the strength of her claim to innocence would have been dissipated by arguing about multiple conspiracies. If you look at the defendant's opening and closing, the defense's theory was not just that there was no reasonable doubt, but that the defendant was actually innocent of any narcotics importation or distribution scheme. The defense claimed on multiple occasions that only an innocent person would let themselves come here and be subjected to a criminal trial to the full power of the United States. Or at 1711, this is also in volume 7, you should conclude that the only person who would come here voluntarily is somebody who was innocent and who had nothing to fear from the case against them. And there are other references throughout the closing opening with the defense's theory being that she wasn't a part of this conspiracy. You never saw any evidence of her meeting with cooperators. You never saw any evidence of her texting cooperators or conspirators. You never saw any cocaine seizures. You never saw any fingerprint evidence. There was just a litany on and on and on of the fact that this defendant had nothing to do with the evidence that was brought into trial. Not that there just wasn't that there was a reasonable doubt.
So the gist of it is high risk, high reward strategy of trying to get outright innocence, and that it would be undercut by an argument that maybe she was a part of this small agreement, but not that.
Agreed, Your Honor. Any suggestion that she actually was dealing in narcotics would completely undercut their theory that she was 100% innocent and came to the United States because she had no worries, that she had nothing to prove.
It's not the most normal thing to litigate ineffective assistance claims on direct appeal. And so just to play this out, in a lot of other courts, ineffectiveness claims aren't part of the appellate chain at all. They're raised on collateral review. In our court, we've allowed for a remand and then a consideration of an ineffectiveness claim as part of that process. If this were to go forward in the trial court, I take it then that then the way that it would occur would be sort of like collateral review, and you could actually have evidentiary development, including testimony from counsel to determine what they had in mind in making the kinds of assessments they did. And we're just kind of guessing at that.
I don't think we're guessing, Your Honor, and that's because, once again, the standard is whether we give a highly deferential and strong presumption that counsel's decisions were reasonable under Strickland. And based on the evidence in the record of what the defense's theory is, we think that's conclusively met in this case. But even if you seem to think that there's some, unconclusive evidence for whether or not performance was deficient, there was clearly no prejudice, and the record conclusively establishes that. And you need to win on both prongs in order to get, or have a lack of conclusivity on both prongs to get a remand. So in this particular case, we do not think a remand is appropriate because the prejudice prong is clearly not met by the defendant.
What's the thumbnail on prejudice?
Excuse me?
What's the thumbnail on prejudice? Why is it conclusively?
The thumbnail on prejudice is that there was overwhelming evidence proven at trial of a single conspiracy, which we've detailed, especially in our variance argument, but also that any potential prejudice that could have existed did not come into play in this trial. There was no evidentiary spillover. Every single message that was introduced, if not almost every, if not all, involved the defendant, and all of them were her discussing actions that would have fallen intrinsically under the conspiracy charge. Her own words established that there was a single conspiracy. There were numerous times where she texted, "I'm gonna bring planes for this or for a US trip," or I'm gonna send you to Jackson, Mississippi, where then we seized methamphetamine. So there is no effect whatsoever on a lack of a multiple conspiracies instruction on whether or not the jury would have convicted this defendant.
Thank you, counsel.
Thank you, Your Honor. We ask that you affirm.
Jackson, we'll give you the 3 minutes you asked for rebuttal.
Thank you. With regard to venue, the government correctly points out, the government on one hand says that we haven't cited a case. Kobar is a case. Kobar is very clear and understandable, but we don't need a case because the Constitution itself sets the terms under which Congress can set venue outside the United States. The government, I think, wants to take the position that anything outside the United States is its own district. And that's fine for an offense that occurs entirely outside the United States. But if anything occurs within the United States, take, for example, let's say everything outside the United States was its own district called Texas. And you had the offense occur in Mississippi and Arizona. And the government brought an indictment here in Washington, D.C. We would have no problem understanding that that is contrary to the Constitution. And that's all that's occurring here. The Constitution sets the terms under which Congress can set venue outside the United States, and they're not met here. I would also point out that the government relies heavily on 3238. The plain text of 3238 says where an indictment, where trial shall take place. The first phrase says where trial shall take place. But the second phrase says that the defendant may be indicted in Washington, D.C. It does not say that trial shall occur in Washington, D.C. So even 3238 would be consistent with the Constitution if the government were reading it correctly. With regard to the variance, I just want to point something out because the government makes a lot of representations about what the evidence shows and how Ms. Fajardo Campos's children were involved. What it doesn't do is establish an agreement between Ms. Fajardo Campos and her children. I understand that a close familial relationship suggests that there should be an agreement when one family member is talking about drugs with another family member. But the evidence established very clearly that Ms. Fajardo Campos dealt with lots of different individuals. Those individuals did not talk with each other. So each time she even where she reached an agreement with someone, she didn't reach agreement and say, And by the way, my son is going to do this, or by the way, there's another person that is going to supply you this. It was always linear. Ms. Fajardo Campos to the person she was talking to, with no rim connecting anyone. What the government leaves out is that this court has emphasized that there has to be interdependency in order for there to be a single conspiracy. And there is no interdependency. There is absolutely no evidence that cocaine was ever imported into the United States. There's none. There is evidence on two occasions, 2012 and 2015, that methamphetamine was ever brought into the United States. I've argued and I still maintain. And those two methamphetamine transactions involved entirely different players, 3 years apart, in different geographic regions. And the only thing connecting them, none of them spoke with each other. None of them even knew of each other. None of them agreed to an overarching methamphetamine conspiracy. And for if you're just going to confine it to methamphetamine, you need the participants to know that they are like dependent on other participants. That did not exist here. So I understand what the government's saying, but there's simply not each factor to establish a single conspiracy. Common goal, interdependency, and overlap. The government relies on overlap, but I'd ask the court to look carefully at the sites the government has provided, because the conversation with Arliss is Arliss asks, the defendant's daughter asks for a plane, and there's no resolution to it. It's not provided. How can that possibly be a conspiracy? And each citation that the government provides is similar. They don't establish even a small conspiracy, let alone one that's related to something much larger.
Thank you. Thank you, counsel.
So can I'm sorry, the very last thing that I want to say is that this court recognized in Coughlin, as the Supreme Court concurrence recognized in Griffin, that when the government charges multiple acts in a single count, it is very important that there are instructions. In Coughlin, this court didn't allow the government to change its theory from one single overarching conspiracy to a much smaller one. Albeit that was a double jeopardy claim, but like the court did not allow the government to change its theory as it has changed its theory here. The government did not argue below that there was some smaller conspiracy that the defendant was guilty of. The government argued below and at all times that this was one overarching conspiracy and everyone was involved and knew of everyone else. And that is simply insufficient, but at a minimum, defense counsel was ineffective for not asking for a jury instruction for the jury to make that determination. If there's any question of that about defense counsel's effectiveness, there should be a remand. Thank you.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 23-5237. Farah appellant versus Jennifer M. Granholm, Secretary of the U.S. Department of Energy. Mr. Shelley, amicus curiae for the appellant. Mr. Walker for the appellant.
Morning, counsel.
Morning.
Mr. Shelley, please proceed when you're ready.
Good morning, and may it please the court. I'm Anthony Shelley, the court-appointed amicus on behalf of the appellant, and I've reserved 2 minutes for rebuttal. The district court's decision below involves the simple misapplication of the familiar standard for stating a claim under Rule 12b-6. Under that standard, the plaintiff need only set forth a short and plain statement of her claim and make plausible allegations that, assumed to be true, could lead to legal relief. And that low threshold is even more generous for pro se litigants like Farah. Yet the district court essentially made every inference against Naz and required her to use the district court's own language to show discrimination and retaliation at the pleading stage. The result was that she was denied her day in court on her plausible allegations. Reviewing her allegations with all inferences in her favor, Naz stated a claim against her government employer for discrimination and retaliation, and the case should be returned to the district court for proceedings on the merits. I'd like to first briefly put Ms. Naz's allegations and theory of the case in their most favorable light, because that establishes that her allegations are plausible and state claims for discrimination and retaliation. And then I'd like to address a couple of the particular errors we deem in the district court decision. First of all, these are the essential allegations and facts. Naz has a master's degree from AU, and she worked as an economist at the Commerce Department for nearly 17 years with an unblemished performance record. She joined the DOE then in 2017, and for another 18 months received positive performance reviews. Then in October 2017, she testified in support of an EEO complaint of racial discrimination made by a colleague at the DOE, Christopher Dickerson, and the allegations were specific. The allegations were specifically aimed at Naz's then superior, Dr. Pearl. But Naz alleged Pearl did not learn of that testimony until April 2018, evidenced by a sudden change in the way Dr. Pearl treated Ms. Naz, going from one of cordiality to belligerence and harassment. At that point, and from then on, from that point when Dr. Pearl learned of the allegations, the testimony Ms. Naz had made, from then on, in a relatively rapid fashion, over 30 months, a series of materially adverse employment actions were thrust upon Naz by Pearl and by Pearl's successors, who Naz alleges sympathized with Pearl. So there was the immediate creation of a hostile work environment from the moment Pearl learned of Naz's testimony, belittling, using racially charged language in a conversation with her, yelling at her. There were immediate behind-the-scenes emails designed to thwart reasonable transfers within the department. They came immediately after Pearl learned of the testimony. There were then repeated denials of training opportunities, denied telework opportunities. She was undeservedly placed on performance improvement plans. She was denied an automatic step increase pay raise. She was given unwarranted poor performance reviews, as she states in her complaint, and she was subjected to unreasonable project requirements.
Can I ask, so the items that you just enumerated, are they all items that are in the plaintiff's complaint?
Absolutely, they are.
I guess, Mike, I have a follow-on question to that, which is, there's also some materials that are in the plaintiff's opposition to the defendant's motion to dismiss, including some allegations that potentially go to a discrimination claim. For example, on page 5 of the motion, there's a reference to a statement. Find it that says that this is allegedly a statement by Pearl, who said, burning with extreme anger and rage, shouted at me, "You will not stay at a place where I will choose for you at a rate of $110 because you Indians/Asian are accustomed to low standards of living and you cannot have a luxury of government's money," et cetera. So there's at least a couple of statements that are made, not in the complaint, but in the opposition to the motion to dismiss.
Correct.
And what is I don't know that there was a reference to those in the briefing, but it's in the underlying materials below. Correct me if I'm wrong. If there's a reference in the briefing, I'm all ears.
In our brief, we did not refer to page 5 of that opposition to the motion to dismiss.
Did you refer to the opposition at all?
We did not.
Okay, and so I take that as a given. So I guess my question is, if there are statements in that submission by the pro se plaintiff below, what do we do with that?
Yeah. Well, the question, I think, is the opposition to the motion to dismiss evidence of sort of amplification of her claims as stated in the complaint. And I will note that she not only had her complaint, but she had a supplement to the complaint, which could be deemed almost an amendment to the complaint.
And just to elaborate on it, and you likely are very well aware of this, but we have decisions in which Whole Foods is the main one, but we have decisions in which we've looked to this exact pleading, the opposition to a motion to dismiss, to elaborate on pro se plaintiff's allegations. I mean, I think that's particularly in the context of a pro se plaintiff. It's just that what the unique circumstance is here is that for our purposes on appeal, what we're reviewing is a district court decision to grant a motion to dismiss. And if the plaintiff or no submissions before us draw our attention to that pleading, then we're naturally going to look at the complaint.
Yeah.
But the fact of the record is that that pleading is there.
Yes. Well, her complaint does note this conversation, that the conversation about the travel, about that she.
But it doesn't include this particular.
It doesn't include that particular, because you Indians, Asians are accustomed to low standards of living. It does say it singled her out for her writing because non-native people cannot write.
Yes, that
according to
allegation,
Mr.
no,
Pearl,
that's in the
Dr.
complaint.
Pearl.
We've got that one, and that's the one.
Yeah. So I would say this, for a pro se litigant, I'm certainly, these are helpful allegations, and it would be in Ms. Naz's benefit to have these considered along with her complaint. I don't think we need them because the complaint is quite voluminous. And it has an Exhibit A and an Exhibit B that are quite detailed. And then she has the additional supplement, but these are helpful. The one thing I will say is I don't think it should then allow the government to bring in everything that they then papered their motion to dismiss with, which was really a summary judgment motion. It was a motion to dismiss and a summary judgment motion. And so I would want to guard against that. If, for instance, including what Ms. Naz said in response to the motion to dismiss is going to open the door for the government to add hundreds of pages of materials that were attached to their motion to dismiss, I would oppose that. But certainly if when a plaintiff who's pro se amplifies and gives details that aren't contradictory to her complaint and does so in an opposition to motions to dismiss, and it's her own statement, this is her own statement, I would certainly have no objection to them being considered in further support of her case. So all of the consequences I mentioned occurred after Pearl learned of the testimony. And so what she describes is a typical situation of retaliation. They meet the plausibility standard because there's nothing outlandish about them. There's nothing against common sense that could have occurred. It's not irrational to think that a superior would have reacted hostilely to testimony that she had engaged in racial discrimination. And what Ms. Naz did was actually far more than what she had to do under this court's case in Rashawn versus Gonzalez, 438 F3rd 2011. And at 1220, the court said there, on causation, in order to survive a motion to dismiss, all the complaint has to say is the government retaliated against me because I engaged in protected activity. That's a direct quote. In order to survive a motion to dismiss, all the complaint has to say is the government retaliated against me because I engaged in protected activity. She has said that over and over and over.
What case is that?
This is Rashawn versus Gonzalez.
From what year?
2005.
Yeah, that's pre-Twombly and Iqbal.
Yes, it is, but I'm not aware that it has since been cited. I'm not aware that that standard has been.
Can I ask one
Sure.
consideration our cases put a lot of weight on is the amount of time that passes between the protected activity and the adverse actions that are alleged to be retaliatory. And here it's at least 6 months. The testimony is October 2017. The hostility begins April 2018. And we've said, I think 3 or 4 months is usually too long. So what do you do with that?
Well, her point is that the person who discriminated against her, Dr. Pearl, didn't know of that testimony. So
How do we know that?
because she alleged it. We have to accept it as true. We have to accept it as true because she alleged.
If that's the basis for that inference, there's nothing left.
But she
in
has-
our timing.
But she has also alleged that in March let's say March, February, January of that year, since from October to April, Dr. Pearl treated her well, was cordial. There were no questions about her performance. She got a good performance review. And then she says in April,
Which is just to say that there's a long time limit between the protected activity and the alleged retaliation. That cuts against.
But it's not irrational to think that Dr. Pearl didn't know of the testimony until April.
No, but the only basis for your saying he didn't know the testimony is this passage of time.
No,
6 months.
Yeah, that's right. The 6 months, I think what we have to do is look at the proximity of the adverse acts to Dr. Pearl's understanding of when the discrimination occurred. One other point about this is that in, actually a couple other points, but one point is that in March of that year, 1 month before, that's when Mr. Dickerson, who had brought the racial discrimination claim, left. And it is plausible to think that once he left, Dr. Pearl learned of all the details of the testimony and the case against her that was brought by Mr. Dickerson. And it is immediately after that Nas suffers the initial bad treatment. The other thing I would say is what the timing rule is it's a presumption. You can assume an inference of retaliation if there's a close proximity. She doesn't need the presumption. She has a couple of other facts that clearly lead to an inference of retaliation. One is for 17 years, she enjoyed wonderful employment and a wonderful employment situation, got no demerits ever. She then testifies, and then all of the bad acts begin one by one by one. The only difference between the two periods is the testimony in between. In fact, one other fact too that's in her complaint is that in 2017, she did a very similar paper to the one in 2018 that Dr. Pearl deems subject to performance review and failure. 2017, she got no criticism whatsoever for that paper. 2018, Dr. Pearl finds every aspect of it problematic. The only difference between the two situations is Ms. Nas testified in between. So she doesn't need the temporal presumption because the other facts add up to one where, well, plausibly, this sea change that occurred may have occurred because of her testimony.
Thank you, Mr. Shiley. We'll give you a little time for rebuttal.
Thanks.
Good morning, Your Honors. May it please the court. Johnny Walker on behalf of the Secretary of Energy. I first want to address the standard. My friend cites Roshan, a 2005 case for this proposition that all a retaliation plaintiff needs to allege is that I engaged in protected activity and the government retaliated against me. This court has said explicitly that Roshan is no longer good law post Twombly. That is in Ho versus Garland, 106 F 4th, versus 47. So Roshan is no longer good law, and what the premise that my friend would have the court accept is precisely that is all a plaintiff alleges. What he asks the court to do is to infer from the mere fact that Ms. Nas experienced unfavorable treatment in April of 2018, to infer from that unfavorable treatment alone that Ms. Pearl, who supposedly perpetrated that unfavorable treatment, knew of the protected activity and performed the unfavorable treatment because of that protected activity. So they're trying to bootstrap the causation requirement of the causation element of a retaliation claim on a mere showing of protected activity and unfavorable treatment. And this court's case law, particularly Ho versus Garland, just does not allow for that.
So you may well be right. I just don't remember it offhand, but you're saying that in Ho, the court specifically discounted the Roshan standard?
The court said in no uncertain terms that it was joining a chorus of district judges in this circuit in rejecting Roshan and saying it is no longer good law after Iqbal.
The court specifically referenced the Roshan language and said it was.
Yes, and I mean, that makes sense from Iqbal. I mean, Iqbal itself is a discrimination case, and the holding in Iqbal was that the plaintiff could not simply allege that I experienced unfavorable treatment. In Iqbal, it was designation as a high interest individual and a detention. and just simply label that as discrimination. There needs to be plausible facts that support that kind of conclusory statement.
Yeah,
And
all that may well be right. I'm just not immediately seeing where we said that in. Oh, can you just point me to?
it is a footnote.
Oh, I see.
Ah, where?
No.
I'm sorry, I don't have the exact
Oh,
page.
I
I
see.
did,
From footnote, maybe it's in footnote 2. Okay, got it.
yes.
Footnote 2, page 51.
So that gets to the requirement that there needs to be some kind of plausible facts going particularly to causation,
Yeah.
and you just don't have those here. All of the protected, that you can get that sometimes with a temporal proximity. There's just no temporal proximity between any adverse action and protected activity here.
But
I want to,
O goes on, does it not, to apply a standard that is somewhat less narrow than the one that you are urging upon us?
I don't think so at all, Your Honor. I think what Ho says is that a plaintiff needs to allege plausible facts to establish 3 different elements for a retaliation claim. They must show that they engaged in protected activity. They must show that they experienced a materially adverse action, and they
No
must show
question
this is
about
what
that,
the,
Counsel,
I'm sorry?
but Ho, no question about that.
Yes.
But Ho also says that we have to resolve Ho's relevant allegations in the light most favorable to him, and then consider their combined effect. And I understood that's what this complaint is all about. Here's an economist who's worked for 17 years, plus 18 months, and all of a sudden something happens. And what's happened? And she says the only thing that happened is she testified against her supervisor in a discrimination case.
No, actually, Your Honor, the adverse treatment occurred many months after her testimony. She testified in October of 2017, and she doesn't experience adverse treatment as alleged in the complaint until April 2018. And that adverse treatment is not even something that's independently actionable. It's the fact that her supervisor got mad at her about a hotel reservation she had made and used some charged language. But so there's a temporal difference between the protected activity and the adverse treatment. The way she tries to, or the way amicus tries to bridge that is to ask the court to infer everything else needed for a retaliation claim from the mere adverse treatment alone, to infer that because
just
she
wanna
was treated poorly.
How government is reading Ho, because Ho goes over these cases saying, oh, that's too long, this is too long, and that's too long a gap. But then it says, Ho's complaint, however, does not rely solely on timing. And then we spend pages talking about all the other things.
Right. No
So
doubt, Your Honor.
I'm wondering how this court is supposed to read allegations on a motion to dismiss appeal.
I think the way to read Ho, and something that we acknowledge, is that temporal proximity is not the only way to create an inference of causation for a retaliation claim. You can show pretexts, you can show differential treatment with other similarly situated employees, but none of that is here. And what I take amicus's argument to be is to try to rely on temporal proximity, but then to close that gap by inferring sudden knowledge to coincide necessarily from the unfavorable treatment alone. So the way they would have the inference go is, my employer got mad at me about a hotel reservation, therefore she learned that same month that I engaged in protected activity. And there's just no reasonable inference to be drawn from that. That's a non sequitur.
I just want to make this separate point. The clock that we're looking at appears to be frozen. Make sure that we have a clock that's maybe in operation somewhere, but we'll keep rough track of.
I'm happy to wrap up whenever your honors are finished with
I
questions.
understood. I just want to make sure that our clock's actually is functioning, but it is. It's okay. You had a question.
Yeah,
Could I follow up on one quick point, Chief?
Sure.
And that is the discrimination proceeding that Mr. Dickerson brought, where Mrs. Niles testified. Did Mrs. Pearl appear as a witness?
I want to clarify something about that. That was not an in-person hearing. What Ms. Nas did was she filled out an under oath questionnaire as part of the investigation.
Oh, we understand that. But
Yes.
the question is, did Mrs. Pearl participate in that proceeding?
I don't think that's in the complaint.
She
I
was
think
the
it's,
person being accused.
yes, I
So
think,
isn't it a reasonable inference to suggest that the commission sought her views?
I think it is, Your Honor. I think that is a reasonable inference to say that she likely knew about Mr. Dickerson's complaint. I don't think there's any reasonable inference to be drawn that she knew about Ms. Nas's separate testimony. That's typically done in a confidential process, and there's no reason that she would know about Ms. Nas providing a separate affidavit.
So I take your point on temporal proximity. I was going to ask your friend says on the facts of this case, we have a nice comparator, which is she submits one report before and seems to be fine, different report after, and it gets not specific criticism about, well, what about this argument or that argument? It gets this sort of global, like, this is terrible response. And the stark contrast between the two is perhaps suggestive.
I think it's somewhat conclusory when she says this report was the same as this other report that was treated the same way, that did not get this criticism. She doesn't sort of like draw out any of those specific facts. And we also know what the criticism was about her California irrigation report is that she cut and pasted nearly all of it from the internet. And so I don't think it is plausible to believe that a government agency that is in the business of publishing studies for public use would find it acceptable for one of their researchers to cut and paste entire portions of their report from the internet and publish that on behalf of the Energy Information Administration.
Well, that's speculation, isn't it? And you don't know what the 2017 report did, do you?
Well, I mean, the
I just want
inference.
to understand, after reading Ho, and after reading some of the Supreme Court's more recent cases, it seems to me there's some loosening up from what there had been in these appeals on motions to dismiss, even after Iqbal.
I don't read Ho that way, Your Honor. In fact, I think Ho stands in a very nice contrast to this case here. In Ho, like in this case, there was a non-promotion claim. In this case, Ms. Nas just says, generally, I was denied promotion opportunities, and it was because of retaliation.
Actually, she said she was denied a step increase.
That's separate. We addressed the step increase separately. We acknowledge that.
Actually, they both involve money.
Well, she doesn't specify any promotion is the problem. But in Ho, the plaintiff there specified a particular job that he had applied for.
Oh, counsel, I'm just saying by analogy, denial of a step increase, that denies the same thing in one sense as a promotion, more money. It may not change your job duties, but you do get more money.
No, I can address the step increase separately. I think that's a separate issue from this general sort of allegation that she was denied promotion opportunities. But contrasting the general denial of promotion opportunities with Ho, in Ho, there was a particular job for which the gentleman had applied. He alleged that many of at least 3 of the people involved in the promotion were specifically the targets of his prior protected activity. He alleged that the ATF, which was the agency at issue there, had a particular need to fill this position and that it declined to fill that position because he and another individual who applied for it had engaged in protected activity. So far more detail than Ms. Nas has with respect to any promotion that she was purportedly denied. And the court in Ho noted that it was a very close case and that it only narrowly got over the line and that any one of the allegations that Mr. Ho had made alone would be not enough. Here, Ms. Nas has none of those obligations, which is clearly not enough. On the step increase, that is a separate matter. That could be a denied promotion. That is the way that the district court read Mr. or Ms. Nas's complaint, and it's the way we read it as well. But as we note, the only protected activity that step increase was proximate to was her own filing of a complaint. And she had received a fails to meet expectations performance rating before that. And that fails to meet expectations rating is what rendered her ineligible for the step increase. So there's no causal connection to be tied to the intervening protected activity.
Can I ask about the opposition to the motion to dismiss.
Yes.
So before a district court as a general matter, when a case involves a pro se plaintiff, our cases say that an opposition to a motion to dismiss is the type of pleading that the court would take cognizance of, including factual allegations in there. You don't disagree with that,
Not at all, Your Honor, yes.
right? So then the question becomes, this one does have some allegations in it that go to discrimination. This one being this opposition to the motion to dismiss. What do we do with that on appeal?
I think there are a few sort of caveats that I'll add to your observation. I think that Ms. Nas filed a few things in the district court that were just document dumps, essentially. And I don't think there's any sort of obligation for a district court to go wading through document dumps and find evidence in the plaintiff's favor. It has to be presented by the plaintiff as such.
I think that's right. There's got to be some apportionment here, but these are on the face of this pleading, and this is a particular pleading that this court has looked to in the past, including in the Whole Foods case.
I also think, obviously, I don't think any of that stuff has been preserved on appeal. This has not been a basis to reverse the district court's argument, but I do want to address the comment that Your Honor highlighted about the hotel reservation. So that was a comment that was supposedly made by Ms. Pearl in this April 2018 incident with the hotel reservation. We certainly do not admit that she made that comment. But we do accept it as true on a motion to dismiss, as you must. So the only two discrimination claims in the complaint were over this lack of promotions and then the termination. So even if you have this indication of discriminatory inference or animus on the part of Ms. Pearl, and it can certainly be inferred to be that, given the charged nature of the comment, it is not related in any way to any promotion that she was denied. As I said, the only sort of concrete promotion denial that she has in there is the step increase denial, which was under a completely different supervisor. That was under Mr. Gross. And then, of course, her termination was the result of a performance development period and notice of proposed removal that Mr. Gross, not Ms. Pearl, put her on. So there's no connection between the alleged discriminatory actions and Ms. Pearl herself. She had no role in them.
Then with respect to Gross, there's a statement also in the defendant's, the opposition to the motion to dismiss that says that Gross said, and again, it's just an allegation at this point, of course, that Gross said that when in response to a request for religious accommodation, that their place of work was a workplace, not a religious institution, and he doesn't believe in Islamic religious extremism. And that's another comment that's in there. And I guess my question is more a procedural one, which is, you may have a response that even taking into account these allegations, which we take to be true at this stage of the proceedings, without saying that you acknowledge that they're true, of course, that they might not be enough. And we can consider that. But my question is a procedural one about what we do with the fact that they exist on appeal. What's the government's view about what we should do with that, given that it wasn't something that I think was brought to the district court's attention. So understandably, the district court may not have taken cognizance of it in the course of its decision, but we know that they're in there, and we know that our cases say that that type of pleading is something that you do take cognizance of in the case of a pro se plaintiff.
Yes, but I don't think there's any error on the part of the district court here when there was so many. I mean, I think her opposition consisted of something over 1,000 pages.
Mm-hmm.
And so I don't think there's any, and then there were some multiple over 100-page, I think it was over 300 pages of supplement files.
Right? Is that what the
Yes, it's not all the time clear when the brief is ending and the attachments are beginning and then the brief is picking back up. So I think with such a prolix nature of filings made by Ms. Nas in the district court, and maybe there are some truffles buried in there somewhere, I don't think the district court erred by not combing through every single page of those.
I think
to find
that's
evidence.
generally true, but okay, then let me ask the question this way, because I think we're just not meeting. Suppose we have a case in which there's a opposition to a motion to dismiss that should be taken into account. You admit that there is such a case.
Yes.
There can be such a case
Yes.
because our cases say that. Okay. So suppose that we have such a case. And then in that case, the district court, for whatever reason, doesn't take cognizance of allegations in there. And it may be that those allegations, were they taken into account, wouldn't change anything. I'm willing to accept that too. But let's just suppose that that sort of case exists. And then on appeal, we're confronted with that confluence of circumstances. What do we do with it on appeal?
Like I say, I think that there is a question of whether or not it was adequately presented to the district court. If it's buried in thousands of pages of filings, I don't think the district court is obligated to construe all of that.
In which case we could just affirm. I mean, but then we would be engaging with the comments and we were reaching the substantive conclusion that the district court wasn't required to look at it because it was at page 573 of a 1,000-page appendix, of a 1,000-page filing, which I totally understand. But I'm hypothesizing a situation in which it's in smack dab in the middle of just make it clear, make it easy. It's a 2-page pleading, okay, and it has some allegations in it, and they just aren't referenced. What do we do with that on appeal?
I think it's a tough question. I do think there's a line between this obligation to construe the pleading in light of subsequent filings and forfeiture arguments. And something that's not properly presented and highlighted is still subject to forfeiture in the district court. And I think it's obvious, and which would obviously permit the district court to disregard that. And obviously there's forfeiture rules that apply on appeal, and we think those rules would apply here where those items buried in the record were not brought up on appeal.
You do, you think that's a forfeiture on appeal here?
Yes.
Is there not an intelligible distinction between her district court opposition, between the brief itself and the 1,000 pages of attachments?
When I looked through them, I remembered being somewhat confused about, because there's items in the attachments that she created. It's obviously her own work product. It's not clear if it was work product that was intended for presentations to the district court, or that she just kept these sort of like as notes herself. Some of them, I think, I'm thinking of particularly, I'm recalling my review of some of the supplements that she filed. They have sort of the district court's name and court number written on them, which makes it seem like they were something she prepared for presentation to the court. But I think in some places, yes, there is a difficulty to draw that distinction.
And in this one, it's, I mean,
Sorry, because just the follow-up I was going to ask you is, suppose we agree that the district court doesn't have to look through the 1,000 pages of attachments, but does have to look through what's in the actual brief in the opposition. And, what result then? And suppose we do the same thing.
Sure.
The cutoff is the complaint and the opposition, not the truffles buried in the attachments.
So I guess then it becomes a question of even material presented in the brief. There's a question of how it is presented and whether or not it is incorporated into an argument. Because if it's not incorporated into an argument in a cogent way, then I think there's still forfeiture principles that would apply.
so here it's on page 5 and page 7 to 8 of the brief itself, regardless of the attachments and everything else that accompanies it. And they're just stated as facts. They're just says, I asked her why the EI, this is on page 5, EIA travel agent had already made that reservation in Naples, et cetera, et cetera. Ms. Kelly Pearl, burning with extreme anger and rage, replied by shouting at me, quote, you will stay at a place which I will choose for you at a rate of $110 because you Indian/Asian are accustomed to low standards of living and you cannot have a luxury of government's money by staying at the Hyatt Regency Hotel at a rate of $236 per night, close quote. That's just on page 5 on the pleading. It's not buried in an attachment.
I guess there's still sort of a separate question as to whether or not it goes to the claims. Obviously, the district court doesn't commit an error by not addressing something that doesn't go to the claims. As I said, here we have the discrimination claims at issue are things that Mr. Gross did, not Ms. Pearl. And I believe the statement that Your Honor just read was from Ms. Pearl about the hotel reservation in 2018. The denial of the step increase was much later by Mr. Gross. The termination was much later by Mr. Gross. And I think even with respect to Mr. Gross's statement that Your Honor mentioned, there still has to be.
I mean, on that logic, then Pearl could have said all kinds of stuff. There could be a litany of 300 pages of direct allegations about Pearl, and it never would matter. And as a legal matter, we can have a question about that. But as on the question of whether a district court appropriately apprised should take account of those allegations, that seems like a different question.
I don't know that it is. I don't think the district court needs to take account of allegations that are sort of gratuitous and don't go to the claims that are proposed. And it doesn't need to take into account allegations that are not sufficiently incorporated into an argument in favor of a claim so as to be forfeited.
Wouldn't they go to a hostile work environment claim? At least I mean, we can have a question about whether the direct supervisors, if you envision one in which repeated claims over time is something that you can just entirely disregard, even if it's a subsequent supervisor who makes the ultimate decision.
I mean, I don't think this complaint contains a hostile work environment claim. Certainly nobody has construed
it references it, but it wasn't developed.
Yeah, it hasn't been developed at all. I think we would have separate arguments about a hostile work environment claim. For such a claim to be actionable, it would have had to been timely exhausted. There would have had to be a cogence and continuance and linkage of all the events. We know that the court has said that, simply trying to regulate a civil workplace is sort of like outside the bounds of a hostile work environment claim. It has to rise to something else. So I think we would have a lot of arguments against a hostile work environment claim. So it wouldn't necessarily go to that. But like I said, nobody has sort of assigned any error with respect to the complaint not being construed as containing a hostile work environment claim.
My colleagues don't have additional questions. Thank you, counsel.
Thank you very much. Please affirm the district court.
Mr. Shelley, we'll give you 2 minutes for a rebuttal.
Thank you. Just a few points. What Host takes aim at Rashawn for is threadbare allegations. And Ms. Naz's allegations are not threadbare. And I'd point the court to the appendix at 14, paragraphs 1, 5, and 7 particularly, where she concisely summarizes a retaliation claim. There she says, Farah Naz enjoyed an unblemished career of nearly 2 decades of service with the federal government. When plaintiffs spoke out against the rampant race discrimination that pervades the agency, she became the victim of a sustained and pretextual campaign designed to remove her from her position. Plaintiff performed her job capably and without critique for the first 2 years at the Department of Energy, but as soon as she agreed to testify against Dr. Kelly Pearl, a hitherto unimaginable degree of scrutiny was trained on plaintiff's every action. Management grew openly hostile to her, mocked her, and erected and resurrected a series of Byzantine obstacles to plaintiff's success that were ultimately used to destroy her storied career. That's not threadbare. I would also say, and the idea that Ms. Naz's paper, what was said about Ms. Naz's paper in 2018 is completely outside the complaint. The idea that it was subpar is not in Ms. Naz's complaint. In fact, she says the exact opposite, that it was an excellent paper and it was, and the statements about it were pretextual. And then the last point I'd like to make is that there were consequences immediately after the April 2018 learning by Judge Pearl, by Dr. Pearl, of the testimony. One is Ms. Naz immediately asked for a transfer, and she was told by one superior, see if you can get that, go talk to various people. And Dr. Pearl in April, May, and June sent emails to all these various people saying, don't talk to her, she's a complainer. And this comes after her testimony in favor of Mr. Dickerson. All those are in the complaint. There's nothing threadbare about it. And it states a typical claim of retaliation. She should have had an opportunity to go to the merits in the usual course and prove her claim. She was denied that opportunity by the district court. So we'd ask that you reverse the district.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission. Thank you. Mr. Shelley, you were appointed by the court to present arguments in support of the appellant in this matter, and the court thanks you for your assistance.
Thanks very much.
Case number 24-7081, Dutch Telecom AG versus Republic of India appellants. Ms. Menaker for the appellant, Ms. Boykin for the appellate.
Good morning, counsel. Ms. Menaker, please proceed when you're ready, and I apologize if I pronounced that incorrectly.
It's okay.
So, good morning. May it please the court. India has reserved 3 minutes for rebuttal. India respectfully requests that this court reverse the district court's judgment, which took the extraordinary step of enforcing an arbitral award against a foreign sovereign without even giving that sovereign, India, an opportunity to brief its preserved merits defenses after the district court denied its sovereign immunity defenses. India has raised several issues on appeal, all of which it preserves. But today I'd like to focus on two of those issues that are primed for this court to reverse the district court's judgment. First, India did not waive its preserved merits defenses when it invoked the P&ID framework. And second, when reviewing those merits defenses, there is not clear and unmistakable evidence that the court should defer to the conclusions of the arbitral tribunal. So turning to the first of those arguments, the district court committed reversible error by violating the two-step framework that this court established in the P&ID versus Nigeria case, which held that a foreign state is entitled to first have its colorable assertions of immunity determined before having to defend on the merits of a claim. And guided
And
by...
the difficulty for you here is that your arguments about the terms investor and investment, and they may be right or wrong as a substantive matter, but they don't seem to me colorable as an immunity matter in light of our cases.
With respect, Your Honor, as of the date when we filed our motion to dismiss, which was back in September of 2021, our immunity defenses were more than colorable at that time. And that is because up until that time, there had been ambiguity and disagreement amongst the courts as to whether our type of an immunity defense, which was that DT...
You have Stillix, which is about the term investment, and Stillix and Chevron are about investment and investor arguments in a bit going to scope.
That's right. They're both distinguishable, Your Honor. In Stillix, Moldova, that case was under the Moldova-Ukrainian BIT, and Moldova argued that the claims did not fall within the scope of the agreement to arbitrate because the investor had structured its investment through the BVI allegedly to evade Ukrainian currency controls. And so that was more akin to an argument that we made and preserved on the merits, preserved on the merits, our fraud argument. They're arguing that the investment was made illegally, and therefore the scope of those claims did not fall within the agreement to arbitrate. In Chevron, Ecuador said again that contract claims that Chevron wanted to bring did not fall within the scope of the arbitration agreement. And in your Next Era 2 case, in fact, you distinguished Spain's arguments from the claimants' arguments that were made, the respondents' arguments that were made in both Stillix and Moldova. And if you look at page 1103, of the Next Era 2 case, you can see there that this court says that in both Chevron and Stillix, the sovereigns argued that they hadn't agreed to arbitrate because the arbitration agreement did not extend to the disputes. So that was a scope issue. And it then characterized Spain's argument as being somewhat different because there Spain was arguing that the Energy Charter Treaty did not extend to EU nationals like the claimants there. So that was an issue as to whether the investor was a proper offeree of the offer to arbitrate in the bilateral investment treaty. And that is akin to the argument that we made before the district court. And so certainly at that time...
You agree that the through line of all those cases is that arguments about the existence of an agreement go to immunity and therefore jurisdiction. Arguments about the scope of the agreement go to the New York Convention merits defense.
Yes.
That's why in this case, there's no doubt that India signed the BIT with Germany and it protects German investors with regard to investment disputes. And there's a question about whether the investor includes the corporation one line up in the ownership chain.
But
It seems as much about scope as can be.
But I respectfully disagree because it is about the existence of the agreement. The agreement needs to be with a party or for the benefit of a party. And here, simply by saying that you are a
There is an
German,
agreement. India has made an agreement with Germany to protect German investors.
but
And
that,
there's a question whether this corporation is a German investor.
correct. And so there, we made an agreement for the benefit of German investors. So one necessarily has to answer the question as to whether you are a German investor that falls within the scope of that
Within
agreement. Within the
That's totally-
confines. Well, I'm using that terminology, I think, in a different manner than the other cases use it when you talk about the scope of claims, because it's very different to say that we agreed to arbitrate with German investors. And my question here, like in Chevron versus Ecuador, but we didn't agree to arbitrate contract claims. We only agreed to arbitrate treaty claims. That's a scope question. But clearly, it cannot be, for instance, that a group of German university students go over to India on vacation and one trips and falls in a hotel room and says, well, I will bring a claim under the bilateral investment treaty. This is made for the benefit of me. I'm an investor. I'm helping the Indian economy. I'm paying for hotels, cab fares, right? There has to be some limitation to determine whether there is an arbitration agreement, whether there exists an arbitration agreement. And again,
In that scenario, the way that would come up in an FSIA context in our court, it would be predicated on an arbitrator actually concluding that it's within the terms of the arbitration agreement so that the arbitrator has jurisdiction, right? So, I
Yes.
mean, I take your point that there's going to be some line drawing questions at some point that seem like under our decisions, they actually do go to the existence of the agreement rather than to its scope. But it would have to be a context in which the arbitration panel or the arbitrator, depending on what sort of procedure followed, would have concluded that the agreement actually does give that claim to them. And it would still have to be so outlandish like the German tourists that it would then come to us and the argument would be made, well, that actually went to jurisdiction rather than to scope.
sure, but you would have de novo review over that. And yes, and there are arbitrator panel determinations that could be outlandish in that regard, but you would think there that the state would have the opportunity to say that they are immune, not just defend on the merits of that claim, but to say we are immune, we never agreed to arbitrate. So I'm not asking you here now to agree with me on the ultimate question of our immunity, but to look back into September 2021 and say it certainly was colorable at that time. And what shows that it was
And what
colorable,
happens after that is next.
well, what comes, it is next era, but the
Is that the main-
fact,
what is there something else? I mean, because.
no,
Okay.
no, it's next era. And the fact that this court heard next era too, and was looking at two divergent, well, there were three district court decisions, as you know, but two divergent ones. So you had Nine Ren and you had Blasket. And in Blasket, the district court judge found, contrary to next era two, you reversed that decision. So clearly there, that was a colorable argument that they were making there at that
district court
time.
decision was post Chevron and still is.
That's correct.
Right.
That's correct. So that's post Chevron, post Stylex, and I think in next era two, the court actually looks, and the way that it's characterizing these cases, it's extending the holdings of those cases. It's an extension because it wasn't clear prior to that time. Another example that we gave in our briefs was the case where actually Deutsche Telekom's counsel is counsel in that case for Equatorial Guinea, Marcel Klinken, where that was 3 months after we filed our motion to dismiss. And the respondent there argued that the district court's rejection of its immunity defense should be reversed because of Blasket, right? So they were making the argument there that that was still ambiguous enough.
Can I ask a question about how you would ask us to construe the colorability standard from PNID? And with respect to two sub aspects of it. So one is, I read PNID as borrowing from Bell versus Hood, which is a pretty strict standard. I mean, it has to be so insubstantial that the claim, if it were brought in the trial court, wouldn't even support federal jurisdiction. So that's part of the question is, what do we do with that standard vis-a-vis colorability in the way you read our opinion? And then secondly, if there's panel precedents, I know you have an argument that even under the panel precedents as they existed at the time, it's still colorable because look at what happened with NextEra and look what happened to district court, one district court. I understand that. But let's suppose the panel precedents are preclusive of that. And so let's suppose it's post-NextEra. Let's make it easy. Let's suppose it's post-NextEra. But then the argument for colorability isn't that you actually have a colorable claim under existing panel precedent. It's that there's an abstract way in which you have a colorable argument because you're not taking the panel precedent as a given because you might win in the en banc court or might win in the Supreme Court. So what's your reaction
Yes.
to either or both of those?
Well, I agree with your suggestions on both, which is first, it's a very low standard or a very low hurdle for us to get over to show colorability. And in a slightly different context, I've seen it as a hint of a suggestion. And if you look at PNID itself, that was a decision of 2020 of this court. And this court said that you reversed and said that the district court had to hear the immunity arguments that Nigeria was making before its merits arguments. That immunity argument that Nigeria was making in that case was the arbitral seat was in London, and a Nigerian court had taken jurisdiction and vacated or set aside the award. And Nigeria was arguing that as an issue of immunity, saying, well, our award has been set aside, not by the court of the seat, but has been set aside, and therefore no award exists and we're immune. And this court found that that was a colorable enough assertion to go back. And what's interesting is if you look at the 2022 decision, because that case went up and down the courts a bit, of PNID, the court here rejects the immunity or upholds the rejection of the immunity claim and finds that it's precluded by 2016 precedent of the court, finding that when an award has been set aside, if you're using that as an objection or a defense, that is a merits defense. Only under the New York Convention, it doesn't implicate immunity. So in 2020, when this court said that Nigeria had the right to have its immunity questions heard before the merits, you already had a 2016 precedent that you said foreclosed the merits of that defense, and yet it was still colorable and it still entitled them to have that heard. So
Is it your position as well that India has had no prior opportunity to present these defenses?
India, that is correct, because on the two immunity defenses that we did raise, no US court has reviewed those defenses because the district court found that they weren't immunity defenses. It then said they would consider them as New York Convention defenses. However, it said that it deemed the parties to clearly and unmistakably delegate the authority for deciding those defenses to the arbitral tribunal, and it had no authority to second guess those determinations. So no one has looked at that. And then with our preserved defenses, no US court has considered those either. And we identify
those arguments have been considered elsewhere, right? And it haven't been met with
only some of
approval
them.
from your perspective.
Some of them. So there are two. One is fraud, one is the essential security interest. Deutsche Telekom acknowledges that neither the arbitral tribunal nor the Swiss court had made any determinations on fraud given the timing of those allegations. With the essential security interest, those courts, the arbitral tribunal and the court had looked at that. But again, that has no bearing on the United States' court's ability to review those determinations. And we contend that the review of those determinations should be an independent review. They ought not to defer to the arbitral tribunal's determinations because there simply is no clear and unmistakable evidence that the parties agreed to delegate to the tribunal the authority to make that determination. The district court relied on dicta in some cases of this court, the Stilex and I believe the Stilex case, when it held that because the bit incorporated or referenced the
Sorry,
uncitral.
You're losing me with the
I'm sorry.
chain. Are we talking about the investor investment arguments that you want to make into immunity, but if they're not immunity, they're substantive New York Convention defenses, or are we talking about the other ones?
I was talking about both.
Okay.
Because the ones that we have not had a chance to brief yet, and that we preserved, of course, we want those heard as New York Convention cases. We had, and to clear up any misconception, we had no intention of getting a second bite of the apple on our immunity defenses. So if they had been heard as immunity defenses, we would not then have re-raised them under the New York Convention. It would not have made sense. They would have been determined. They have not been heard, though. So if we went back, we would want to raise them under the New York Convention. Of course, we'd want.
So as to those defenses, the investor and investment, but not the other two.
Yes.
Then we come to the question whether the district court, so he says no immunity, but he goes on to resolve them as New York Convention defenses. And he says, it's not for me to decide because those defenses were delegated to the arbitrator.
Correct. So that's what he said, although we say that is incorrect because we didn't delegate those to the arbitrator, nor did we delegate our preserved merits defenses to the arbitrator. The only thing that the district judge looked at was the fact that the UNCITRAL rules governed the arbitration, and those rules contain a standard competence clause. There is no clear and unmistakable evidence, and that's of course the standard under first options, that the parties to this dispute, to the bit, which is to be interpreted as a contract, that they intended to delegate exclusive authority to the arbitrators to determine these issues. And if you look at BG versus Argentina in the US Supreme Court, the court there says very clearly that ultimately interpreting a treaty is like interpreting a contract, and what is important is the intentions of the parties. And here we have two things that I think are of utmost importance. One is
Argentina, counsel. This court was reversed in BG versus Argentina because the Supreme Court said to us, all of these questions, regardless of the facts sovereigns are involved, are to be decided by the arbitrator.
yes. Yes, no, and that's.
I take that as very strong language from the Supreme Court.
Yes, but what the Supreme Court said when it had made that determination, it said that what you need to do to determine if it is to be resolved by the arbitrators is to look at the contracting party's intent. And so that's what I want to look at here. And here, the contracting parties to the treaty are India and Germany. And there can be no doubt that India and Germany understand the UNCITRAL rules and Article 21 in particular to afford the arbitral tribunal an initial determination of these issues to be later reviewed by a court. And that is absolutely, Deutsche Telekom doesn't contest that. That is their understanding of those clauses. And when you look at our bit in particular in Article 9 2B5, it says that the award shall be enforced in accordance with the national laws of the contracting party where the investment has been made. That's Indian law. So, and we have other arguments, of course, that we construe that choice of law clause as being a forum selection clause, but even at its most narrow, as a choice of law clause, that means that in enforcing this award, we have to apply Indian law. There is no doubt that Indian law interprets the UNCITRAL rule as simply giving the.
So can I just ask a
Yes.
question about where this fits in the overall architecture of what we have before us? So you took a collateral order appeal from the denial of dismissal on jurisdictional grounds, right?
I think not. I think we waited until final judgment was entered. It was a few weeks later.
Okay, true.
Yes.
Yeah, okay, so, but then what do we have before us? Because we clearly have the jurisdictional question before us. And then if we, suppose we disagree with you on jurisdiction, so that we assume that the questions that you think are jurisdictional ones actually go to scope. Let's just suppose that. I know you
Okay.
resist that, but let's just suppose that. If that's true, then we also have before us what the district court did to go on and decide the merits of those two, of that question, as opposed to the ones that are just bracketed off and never addressed by the district court because the district court said that those were effectively waived or forfeited by you. So if we go on to the UNCITRAL question, the question of does the provision in the UNCITRAL that deals with what the arbitrator has jurisdiction to do, we address that one as well
Yes.
in this appeal. If we
Yeah.
get past your jurisdiction.
I believe so, because the court, if you go back and say that it was error to deny you can either deny our foreign sovereign immunity defenses, or you can say, well, they were denied, they should have been scope. However, you should not have then said that we waived our ability to bring the merits defenses. And then since the court in its order has already said that it finds itself bound by the arbitral tribunal's determination of those and wasn't able to second guess, I believe that that is then before you now, and we're asking you to reverse on that. That is a de novo determination whether there was clear and unmistakable evidence that we intended to delegate this question to the arbitrators. And so if you reversed on that, then saying there was no clear and unmistakable evidence of delegation, then it would be remanded, vacated or remanded, and we would have heard our New York Convention defenses under an independent review standard.
The Indian law that you cite as invoking a model that the arbitrator gets to decide arbitrability questions in the first instance, then subject to judicial review. Is that specific to UNCITRAL or just general, like India's version of BG, just this is how presumptively how things work?
I would need to double check, but I believe it does contain some case law that would have dealt with UNCITRAL because India, for instance, is not a party to the ICSID convention.
So they go under
And
UNCITRAL,
they-
not ICSID.
Exactly.
So I mean, I guess the reason I ask is we have cases, the same cases I was citing at you earlier, those cases say that invoking a provision in the contract which calls for application of UNCITRAL rules, which permit the arbitrator to decide questions of arbitrability, is sufficient to assign those questions exclusively to the arbitrator.
Sure. And I just have a few responses to that. That first of all, those cases are looking, again, what you need to do in each of the cases is just not to say that there are the UNCITRAL rules which are being referenced, but you have to look at the intent of the parties. And so the court presumably did or should have looked to the intention of the parties in those cases to those particular bits to determine if there was clear and unmistakable evidence. And that's what we're asking this court to do here, is to not have any flatline rule. We need to look to the intention of these parties. And there's just no way that India and Germany intended to delegate exclusive authority to the arbitrators when in
Because
our
of
submission,
how the background law works.
because the background
So is the
law
background law-
and
You can't fault.
No, oh, go ahead.
No.
I was just, I mean, what's odd about this is if you were thinking about the world from first principles, you might think that only the judges can decide these questions, or only the arbitrators can decide these questions, or door number 3, the arbitrators decide in the first instance and the judges review, which you say is Indian law. And yet, BG says your options are door number 1 or door number 2. And I don't know what to make of that. I mean, tend to think I'm bound by Supreme Court precedent, but is that just no one in any of these cases is thinking that a contract might provide for door number 3? Is that what's going on?
well, I think that the US is somewhat unique in this regard because I don't know of any other jurisdiction that does interpret these provisions in the manner that the US courts have done on occasion. But
Because
again-
our non-FSIA, FAA law is so arbitration friendly.
I don't know why it is.
Okay.
I think that, but I also think that BG in Argentina, and not to just repeat myself, but there first it was looking at a different issue. It was looking at a procedural time issue. But it did emphasize, the court did emphasize that what you need to look is for clear and unmistakable evidence, and you need to look at the party's intent. And I'd also just point the court's attention to a statement in DT's opposition that we have quoted, where they say that, and I quote, this is at 21, through the incorporation of the UNCITRAL rules, India agreed to, quote, to delegate disputes about arbitrability to the arbitrators, subject only to post-award judicial review. That's what we're asking for, is post-award judicial review.
Yeah, I'm not, the thing about that is, that may well be the background principle in Indian law. I'm not sure that that's not the background principle all over the place.
Mhm.
But yet we still have these decisions that treat the UNCITRAL provision and the parallel one under ICSID as not only creating a regime in which the arbitrator gets the first crack, subject to judicial review, but it's creating a regime in which the arbitrator gets the first and last crack.
Well, I think
And
there,
that just seems like that's, I mean, this competence idea is not some, unique principle that applies in the narrow corner of the universe. It seems like it's a pretty universal one abroad, but yet we still have, our decisional law still says that these particular provisions, I think it's basically parallel between UNCITRAL and ICSID, that what they do is that they give it to the arbitrator in the first instance, and that's exclusive of subsequent judicial review.
well, I would disagree with that because there is a very material distinction between UNCITRAL and ICSID insofar as ICSID has a two-tier layer of review. It's an independent review. So after you have your arbitral award, if you want to review that under essentially the same standards as the New York Convention, I mean, slightly different, but it's ICSID Article 54.
It's more different.
It's differential, but what you do is you don't go to court to do that. You have a second tribunal. It's called
Within
an
the
ad
arbitral
hoc committee
process, sure.
within the arbitral process. So you have
Yeah.
two, and then when you go to court, it's a much more summary procedure. So I don't think it can be compared because of course you're deferring to the tribunal or the ad hoc committee. You've already had your level of review. Whereas here with UNCITRAL, you haven't. And I would just also point the court's attention to the DTK versus Hotels case, which was before the Second Circuit in 2021, when we're talking about these arbitral rules automatically meaning that you delegate to the arbitrators an exclusive determination. The Second Circuit cast that into doubt when it said you have to look at the particular circumstances, which is what we're saying here. There, it was an arbitration clause under or an agreement governed by the AAA. There was a AAA arbitration, and yet there was a question as to whether the clause covered the scope of dispute that was being dealt with. And the Second Circuit said, we find it ambiguous. It's an argument, maybe it's covered, maybe it's not. So we're finding that it's not clear and unmistakable evidence that you delegated this to the tribunal, and we're going to look at it ourselves. So even there, when the AAA, I think, is clear when you look at the history, the legislative or statutory history, when those rules were promulgated, that they had first options in mind and they wanted to make this delegation. That's not the case for the 1976 UNCITRAL rules for certain, but even in a case governed by the AAA rules, the Second Circuit saw that there could be exceptions based on the particularities of that case. And that's what we contend should happen here, particularly also, I would also note, with both Chevron and Stylex, which contain the language about the UNCITRAL rules delegation, I note that the parties in those cases did not brief and argue that issue. So in that respect, the court didn't have the full ability or the full opportunity to hear argument on that. And to the extent that they just accepted or acknowledged that point and were happy with that standard of review, we don't think that that should bind us going forward. And in that sense, we have called that dicta.
Okay.
You have authority for the judicial review model under Indian law. Do you know what would be the standard of review? The cases don't seem to speak to it. Is it de novo review on arbitrability? Is it review for reasonableness? Is it review under the US, super deferential? Does this rise from the essence of the contract standard? What is the level of scrutiny?
I understand the question. I don't know the answer, and I apologize. I can get back to the court on that if you would like.
Okay, thank you, counsel. We'll give you a little time for rebuttal.
Thank you.
And we'll hear from the other side now. Mr. Boykin.
Thank you, Your Honor. James Boykin on behalf of Deutsche Telekom, petitioner and appellee. I will first address the argument that the second issue on appeal as to whether the district court erred in not giving India a second round of briefing. That's foreclosed by their own conduct. P&ID gives a state an absolute right to invoke immunity defenses, but it also recognizes the inherent right of the sovereign to choose to raise immunity defenses together with merits defenses, with, however, the consequence that it would, in so doing, it forgoes the right to have the immunity determination made as a threshold matter. In this case, India did not raise any colorable argument of immunity. But even if one were to look inside and their motion to dismiss and find a colorable argument of immunity, one cannot overlook the fact that India raised merits defenses. And those merits defenses were specifically that there was no investment and there was no investor. Now, India tries to say this was colorable at the time and was cleared up by NextEra. That is not correct. And they
But
do
when
so.
you're saying those are merits issues, that India was presenting them as jurisdictional arguments, right?
Right, but this court's clear precedent at the time in Chevron and Stilex held that these do not go to jurisdiction or immunity.
Okay, so then that goes to whether they're colorable jurisdictional arguments, not whether they're merits arguments. And
We say yes, they're merits arguments.
no, but no, I think the question is, maybe I'm misunderstanding the architecture here, but I thought those are being presented as jurisdictional arguments. You disagree that they're jurisdictional arguments. You may, let's just suppose you're right about that, but that doesn't answer the question of whether they're colorable jurisdictional arguments. And if they're colorable jurisdictional arguments, India did not then need to go on and make merits arguments. At that point, they could have reserved their opportunity to make other merits arguments.
Fair enough. In that framework, I would say they're not colorable because Chevron and Stilex have already held that those defenses are not immunity arguments. They go to.
So what about the point that as to that, what about the point that even NextEra hadn't been decided?
Right.
So we were in a Chevron Stilex land.
Yeah.
There was a district court decision, as counsel pointed out. The district courts went two different ways and on the NextEra question. So was that district court decision that went a way opposite of the way we saw NextEra? Did they get it so wrong that actually it doesn't even meet the Bellevue Hood standard for whether it's a substantial argument?
But NextEra didn't decide any question that was relevant to this case when their motion to dismiss was filed. And India's own brief or the reply brief on page 6 acknowledges that NextEra really concerned Spain's legal capacity to arbitrate. It had to do with a question of EU law and whether Spain had the legal capacity to arbitrate with persons within the EU. The questions that they framed in front of the district court in the motion to dismiss in this case were clearly covered by Stilex and Chevron. On their motion to dismiss, page 27, they complained that the supposed investment under the agreement was indirect. And that in page 26, they talk about DT's status as an investor. And there's nothing about Germany's capacity to have entered into the agreement with India. There's no allegation that the treaty was never ratified, which would go to the
But
existence.
it has to not even be colorable, including on the direct indirect one. And just just to tease out what exactly the colorability threshold entails. Suppose you have a situation in which the panel precedents that you're relying on, and again, we're in a pre-next era stage.
Yeah.
Suppose you have a situation in which the panel precedents that you say make a claim non-colorable under those precedents included a dissent. Then would you say that the argument is just non-colorable because the panel precedents say they don't go forward, even if there's a panel dissent and the case has never gone before the en-banc, the issue has never gone before the en-banc court, much as the Supreme Court?
Yes, if it's controlling precedent, it's not colorable. And I think the
Even if
most,
there's a dissent and it's never gone before the en-banc court and it's never gone before the Supreme Court.
I think there's precedent in this circuit that it's bound to apply a panel decision.
Oh, there's no doubt. We're bound by it. I think there's at least a subsequent panel would be bound by it.
Right.
I guess my question is.
Oh, your question, is it colorable in that
colorable?
context?
Right.
Right, but the question, these questions of investor investment have been settled with Chevron, Stylex, and
But
Next
I
Era
guess
did
the
something
question is,
different.
were they so settled that were they so obviously wrong that it's not even colorable? I know that there's panel precedents that you say make them wrong. The question is whether they're not even colorable.
In our view, if they're foreclosed by clear circuit precedent that's been consistently applied, then they're not colored immunity defenses. Because otherwise, the result is going to be that every state will come and reassert merits defenses as immunity defenses and to claim they're entitled to the two-step process. And this circuit court can say over and over again, those are actually go to the merits. And it must be the case.
Well, there's definitely a colorability threshold. And so you're right that at some point something becomes non-colorable. I guess the question is, how strict is that standard?
It's pretty low. It's in P&ID. It has to be plausible. But our position is that once it's foreclosed by a.
One can imagine lots of cases where there's binding circuit precedent and a plausible opportunity for in-bank or cert. It's like they take the appeal and say, they seek initial in-bank.
And well, that would be for you.
Dissent.
Right. But if you read Next Era, it decides something new that is not relevant to this case, but it very heavily relies on Chevron and Stylex. And those are, there's no indication that Chevron and Stylex are set up for en banc review or that there's questions about their authority. In fact, this court just relied on them in, as my colleague pointed out, a number of consolidated cases concerning the EU dispute and Spain's authority and power to arbitrate. And district courts reached divergent results on that because it involved a sovereign saying we are constrained by EU law. That was a novel question. That was a colorable argument of immunity. But Chevron and Stylex, on which Next Era relied, those are settled. There's no, so these arguments weren't colorable under the very low threshold, concede that it's, but it's not. And I think there's some, there's also, they knew they weren't colorable. No, I mean, one other indication of the lack of colorability of the argument is that in these briefs, it's framed as our proper offeree argument. And in their first, they filed on June 24th a statement of issues that the district court erred in holding that the arbitration exception applied. In their brief, in their statement of issues, they say the district court erred in not giving de novo review to a proper offeree defense. But they never made a proper offeree defense to the district court. They don't use those words in their motion to dismiss. Those were proper offeree defense wasn't even in the statement of issues after they filed appeal. That those words emerge and they encapsulate investor and investment. They emerge after Next Era. So what they're doing is essentially rewriting the motion to dismiss to make it look like it was something akin to that what was undecided in next era. But it's not. There was never never a proper offeree defense argued to the district court. So it's hard to criticize the district court for not having ruled on an issue not put before it. And second, what is a proper offeree under the BIT?
Can I ask a question about the incentive dynamics that would be at play if we construe colorability in the way that you are, because in the way that I think your argument suggests, because I take it that what would then end up happening is that a foreign sovereign, because they'd be worried that the jurisdictional arguments they made may be seen to be non-colorable under panel circuit precedent, would feel like they need to make every merits argument that they have in their initial pleading. So you could have a threshold jurisdictional argument, and then you have 27 merits arguments that follow it, all of which are going to be briefed by a foreign sovereign. Then the district court, understandably, would say, I don't want to deal with all these merits arguments because I think there's no jurisdiction here. And then we'd be in a situation in which that all could have been resolved at the jurisdictional stage, but then the foreign sovereign would, because of concerns about being deemed to have waived merits arguments, would have felt the need to develop and introduce that kind of array of merits arguments.
The foreign sovereign need not have such a concern under P and ID, which expressly recognizes its right to a two-step process when it raises colorable immunity arguments.
Right, but this places all the load-bearing weight on whether it's colorable. And I guess what I'm saying is, if we don't have a very, very low threshold for what's colorable, then a foreign sovereign who's going to be careful just can't risk it. You got to include all your merits arguments, because I could be seen to, for example, in this case, even if there's not, next era hasn't come along yet, maybe Chevron and Stilex say that this is non-colorable, and therefore I'm just going to and India happens to have a couple more merits arguments. I'm sure there's other cases in which a foreign sovereign has many, many more merits arguments than that, but they would feel compelled at the threshold to include all of those. And I just wonder whether that's a healthy incentive dynamic.
I mean, the foreign sovereign has the incentive to raise all of its colorable immunity arguments in its first brief.
Mhm.
And it has the right to choose to raise merits arguments at the same time or not. So it cannot waive merits arguments if it raises only colorable immunity arguments. And so the policy and administrative angle that your question was approaching is better served by sending a message that if you're going to invoke the two-step process, pay attention to this circuit's precedent about what is an immunity objection and what is not. And that's a reason, that's still a low standard of colorability. A colorable argument, we admit, should have a low standard, but to have a decision that requires sovereigns to look at controlling precedent of the circuit as to where that line has been drawn.
Suppose you have a situation in which, with the circuit in which you are, is an outlier. So you have panel precedent that, let's just say, clearly forecloses an argument. But then every other court of appeals, there's 8 other courts of appeals that are pronounced on the question and disagree. Would you say that the argument is non-colorable, and therefore all the merits arguments have to be included because in this circuit, the law points in a particular discretion? And it's clear in this circuit, and it's only panel precedents. The panel precedents point.
No, if there was, I would say it's colorable immunity. And I've never said they have to include merits arguments with a colorable immunity. A sovereign has a right to make that choice. A sovereign has a right, though, to a threshold determination of immunity. So if you had 8 other circuits, that would be colorable. But once the sovereign brings in what are clearly merits defenses, it has waived its right to a second round of briefing. That's the only conclusion for which we're advocating, that they've essentially briefed all of their merits defenses, and the judge was entitled to rule on them. And this gets us into sort of the judge was entitled or obligated under the law because of the USCA rules, and that the parties delegated the intent to decide issues of arbitrability to the arbitrators. And my colleague said that the judge did not consider the intent. The district court looked at the USCA rules. He construed the treaty as a contract, And he considered their extrinsic evidence, and he said, even if it were proper for me to consider that extrinsic evidence, it doesn't override the language in the contract that has the UNCITRAL rules and the delegation. And as for the background law of India, requiring de novo review, they did get de novo review of the arbitrator's decision by the Swiss Federal Supreme Court. And there's no proposition of law that requires a court of secondary jurisdiction like this, like a district court sitting as a court of secondary jurisdiction in a convention case, to follow Indian law. Rather, it has to follow the Supreme Court and look to the fact that the UNCITRAL rules delegated these questions to the arbitrators. And on page 25 of our brief, we cite a number of cases that require the district court to defer to the judgment of the the court of primary jurisdiction that scrutinized the award. And especially if they vacate the award. Well, if the court at the seat confirms an award, it should be at least entitled to the same degree of deference as when it vacates. And that's what happened here. All of these issues have been aired and ruled upon.
The district court's rationale on the merits, looking past immunity to the merits, was that arbitrability was assigned to the arbitrator through the incorporation of UNCITRAL.
Yeah.
And for that reason, the district court couldn't review the decision. And that's different from the alternative that you just floated, which is the district court can't or shouldn't review arbitrability because a Swiss court has decided.
Yes, that's different. Those are two distinct lines.
Those are two distinct. Like the second one raises all sorts of questions about the issue preclusive effect of foreign judgments, which the district court didn't get into, potentially messy. I would think that one is a little uncomfortable as an alternative.
And you need not reach it because the district court was.
Let's go back to,
Yeah.
That's what I thought. So that takes us back to, is the issue off the table by virtue of incorporation of UNCITRAL rules? And you have precedent, you have some good precedent, no doubt. But this contract seems to provide for Indian enforcement law to govern enforcement questions. And if it is the case that Indian enforcement law has this model that arbitrators decide arbitrability questions and then there's judicial review, why don't we follow Indian law per the contract?
Well, I would say they did get the judicial review that when they agreed, Deutsche Telekom and India agreed on the seat of arbitration in Switzerland, where the law is that the Swiss Federal Supreme Court reviews questions of arbitrability de novo. They don't have a first options. And this court, one, we disagree with their contractual interpretation, that's in the brief, but this court, the Indian law does not so clearly override the evidence of intent. And Judge Leon at the district court level took it into account. He referred to it as extrinsic evidence, and he said it didn't override. And that's a factual finding that you would need to find was clear error. And then there was a lack of intent to refer questions of arbitrability to the arbitrators, because he did look at India's evidence and he said, even if I were allowed to take in all of this extrinsic evidence, it doesn't outweigh the
I'm not sure why it's extrinsic evidence. We're construing the bit, and one provision incorporates UNCITRAL, which cuts in your favor. The other provision says apply Indian enforcement law, which cuts in their favor, and this is an interpretive dispute about.
So let's look at the bit and what it says, because it doesn't say apply Indian law to enforcement. But maybe you have a clause in mind.
Arbitration shall be enforced in accordance with national laws of the party where the investment was made.
Right. And in our,
India. And like their argument that enforcement can only happen in India, I completely disagree with. But their narrower argument that Indian enforcement law governs enforcement wherever enforcement happens seems, I don't want to confuse things, but seems at least colorable.
right, well, it was, first of all, it was waived because it was never made to the district court. And all they raised in front of the district court were merits defenses. So, second, in our opposition to their motion to dismiss, and I don't have the page references in my head, but we explained what this clause means. It may also be in our reply, but there are authorities that explain that this is a guarantee that states will not change their laws when it comes to enforcement. So
You
and make
say
it more
is-
difficult.
You say it is uniquely addressed to India and prohibits India from imposing distinct enforcement. Like they can apply their generally applicable law of arbitral enforcement.
right, there's
Can't target this.
exactly there's
It reads more broadly though. Just says the award shall be enforced in accordance with the national laws of India.
where the investment has been made.
Right, which here is India.
Right. And we was in the opposition to the motion to dismiss. There are authorities that look at provisions similar to this that say that this type of phrase, what it means is that a state is promising not to change its laws to make enforcement more difficult. It cannot be that Germany and India have the power in a treaty to impose upon a United States district court acting as a court of secondary jurisdiction a standard of review. That court must comply with the laws of the United States. And
I understand why you say that, and
we're not, the word shall be enforced in accordance with laws. Let's assume Indian law does require de novo review. They obtained de novo review at the Swiss Federal Supreme Court. We sought confirmation and recognition. That's not enforcement.
Suppose that the agreement actually forecast everything that's come to pass. And suppose that the agreement, the provision actually spoke clearly to this and just said, the arbitrator's determination shall not be final, and a court of judicial review in any other country shall, of course, under the principle of competence that spell it out, shall have authority to review that determination. Then are you saying that that wouldn't be operative here?
I think it would be, a court could choose. I mean, two sovereign states cannot contract and affect a court's jurisdiction to other foreign sovereign states. No more than two private contracting parties.
No, but on the question of whether the arbitrator's determination is final and conclusive and can't be reviewed by another court, by a court.
Oh, if it said it's not final and conclusive, then it probably wouldn't be a convention award. Because the convention, I think you have to have a final award to, or it couldn't fit under the FAA. It's not final and binding.
It's final, conclusively resolved by the arbitrator and then subject to judicial review.
De novo.
I mean, it might be de novo or it might be for reasonable.
Regardless of the standard, I mean, I think because what the district court said, and understandably in light of the language in some decisions said, is that because the onsen trial provision provides for the arbitrator to decide arbitrability,
Right.
then the incorporation of that provision means that not only the arbitrator gets to decide it, but that the arbitrator's decision of it is preclusive of any judicial review. And all I'm saying is, suppose you have a contract that just says, no, under this agreement isn't intended to do that. What this agreement is intended to do is to preserve judicial review.
Right. If you had a contract that said, no, we intend to preserve judicial review of issues of arbitrability, then there would not have been an intent to delegate those issues but
Because I
you know,
thought some of the arguments you were making was that a US court would never have the ability to give effect to such a provision.
I had understood your question to mean more, to be broader than on arbitrability, because the presumption is that courts review arbitrability and first options is an exception. What you're saying here, and was getting at that the law of India, two contracting parties cannot expand the scope of the federal court's authority, but they can, of course, if it's evidence of intent on the question of arbitrability, that needs to be taken into account. But
Let me try it this way.
okay,
Do private parties have the power to contract for an arbitration scheme where the arbitrator decides arbitrability in the first instance, and then enforcement courts review those decisions?
yes,
Okay, so then we're just talking about whether this clause
overrides the reference to the uncitral.
accomplishes that,
Right,
notwithstanding the reference to.
right. And the district court found that it did not. And I think
I don't know that the district court found that it did not. I think the district court thought, under the language of some of our decisions,
Right.
the mere incorporation of the uncitral means that
Everything's off the table.
respectfully, Your Honor, I'll quote from the district court at page 8. It says, while India purports to offer extra contractual evidence, and just kind of, I take your point, that would be contractual evidence, so I'm not relying on that. But he did consider this language part of it. He says, is even assuming it would be proper to consider, it's sufficient to overcome the clear and unmistakable evidence found in the BITS incorporation of the uncitral rules here.
But it's just the incorporation of the uncitral rules. He thought, and I'm not saying that there's not support for that proposition, there is, but he just thought that that was the end of the matter.
He thought that that clause wasn't enough to override the clear and unmistakable evidence found in the BITS incorporation of the uncitral rules. So, I mean, he did consider it, he didn't ignore it. We agree with him that that second sentence isn't sufficient to override the reference to the uncitral rules. And we have other evidence of the party's intent is when they chose Switzerland. And they got de novo review of all these issues in Switzerland. And this court, the district court, is simply applying U.S. procedural law. What does U.S. law require me to do when I'm sitting as a court of secondary jurisdiction? I defer to the arbitrators, and I'm going to go back to our cases on page 25. There are, and I'm not invoking these as res judicata, but simply there is a public policy in the United States of recognizing arbitration awards, and there's a consistent line of cases that say we give significance to the court, to rulings of the court at the seat in terms of vacature. Our point is confirmation is at least is worthy of the same dignity as if a court had vacated.
Did the Swiss court err in reviewing the arbitrability questions de novo?
No, that's Swiss law. That's well-established Swiss law that was known when the parties chose Switzerland as the seat of arbitration.
So then this whole question comes down to the difference between the law of the seat of the arbitration and the law of a secondary enforcement court. It's not, it doesn't come down to the line between arbitrators and courts, which is.
That's right.
The district court seemed to think.
Right. And the law in Germany required de novo review.
Go ahead. Sorry, counsel. Continue.
No, I apologize. Your question is more important.
Well, I think the judge would like to hear your answer.
Okay, well,
I'm sorry.
Okay, the law in Germany required de novo review of these questions. And the Congregation considered investor and investment and found, agreed with the Swiss federal court and the arbitral tribunal. The law in Singapore required de novo review.
So if that's true, then this sentence read in light of those, you have to read this sentence to mean arbitrator decides arbitrability. Swiss court gets to review those questions de novo, but no other enforcement court can.
Right. And
Where does that does not come from BG or Chevron or any of those cases. It sounds plausible. I'm just not sure where it comes from.
there's
I
a,
was about to suggest that I think, at least this is just my opinion, that a lot of American courts are uncomfortable with arbitration. All right, and that what was contemplated was that these sovereigns who have a lot of experience, a lot of legal talent available to them, make these decisions to arbitrate because of the incredible financial awards. And the only way they get these awards is not to have these matters bogged down for 20 years in the Indian courts or elsewhere. So now we have two sovereigns. They enter into an agreement to arbitrate. They've chosen the court that they want to review any questions. They've been there not once, they've been there twice. And the Swiss court has ruled. And so now what's left for what we're calling the court of secondary jurisdiction? And this court has issued a lot of very strong opinions saying we're out of it, basically. And we've fooled around with what does arbitrability mean? How broad is that term to be interpreted? And maybe we're going to switch to a different arbitration system than was described in BG versus Argentina and subsequently by the Supreme Court. But that's what's so troubling, that this is not the normal way that things go. And what, we don't trust sovereigns to make these decisions in their own interest. And therefore, this enforcement role of the secondary court is very limited. We don't start all over again. Now, maybe all that's going to change. And we'll see what position the Justice Department starts taking in these cases. But that's why it's very troubling to me that we've had all these proceedings, been twice to the court that the parties chose. And now, basically what I read the district court as saying is that the DC Circuit has made it very clear what its position is on a lot of these issues. And basically, there's a very limited role for the enforcement court. It has to find three things. If it finds those three things, its role is done, other than issuing the orders and moving forth on, you know, even the award goes back overseas in this case. So that's what's troubling to me here. And if we're going to rewrite this whole scheme, fine, but we have to be clear that is what we are doing.
Your Honor effectively encapsulated our position. There's no proposition for de novo review by every court where confirmation and recognition are sought. It's free, states are free.
You heard counsel for India say, though, that they had not had the opportunity to raise these merit defenses. And your response is, well, they raised some. And the law is you get a chance to raise merits defenses, and those you don't raise, you forfeit. And that's what happened here. And there's a comfortable feeling about immunity that necessarily our court has. And that's what I hear coming up in all these questions. Maybe I misunderstand my colleagues' concerns, but that's just one view. And so what's your best answer to satisfy what I'm identifying as a level of discomfort here with the system that the Supreme Court has endorsed, that Congress has endorsed in several actions, and now this court has repeatedly endorsed?
That if such a level of discomfort exists, this is the wrong case to address it. India has litigated all of its objections before the arbitral tribunal, before the Swiss Federal Supreme Court. They were briefed before this court. They went before the district court and asked for a stay to go back to Switzerland with, supposedly evidence that would result in vacature and what would render, in the district court, they said, could render it moot. He let them go, stayed for a year. Swiss Federal Supreme Court said, no, we're not going to vacate. Those are the same facts about illegality that you knew during the arbitration. And they found you waived. They tried the same argument, the Singapore Commercial Court, all of these same arguments. Justice Reyes writes a wonderful decision analyzing each of them de novo. The Singapore Court of Appeals analyzed all of these questions, and they have had 5 opportunities.
Let me just ask maybe one last question, which is just to make sure I'm understanding your arguments about waiving merits issues. If we think that the arguments that India presented as jurisdictional arguments are colorable jurisdictional arguments, but we agree with you that they actually ultimately don't go to jurisdiction, they go to scope. But let's suppose we think that they're colorable. Then you don't say that if that's true, India waived its ability to present the merits arguments that aren't wrapped up in jurisdiction at all, that the district court just didn't pronounce on at all.
If they raised arguments on the merits together with colorable arguments of immunity, the essential security question they invoked in their motion to dismiss, that was a merits question at the arbitration. That wasn't jurisdictional. They raised questions of, you have to read their motion to dismiss and find it only raises questions of immunity, colorable questions of immunity. And we say it does not. Investor and investment, that's Chevron and Stilex, but there was also, and there's pages devoted to briefing allegations of illegal conduct, and yes, they reserve the right.
I'm just talking about the merits arguments that the district court did touch on.
Right.
What the district court said is, enough is enough. I'm not going to look at those merits arguments at all. You should have flagged them, but you should have briefed them, but you didn't at all. Those merits arguments. As to those, if we disagree with you on whether the jurisdictional arguments they did raise were colorable, so that we think they were colorable, then I'm not aware of any reason that somehow they waived the merits arguments that the district court didn't touch on at all. But maybe I'm missing something.
Yeah. If you find that they only raised colorable immunity objections, then the PNID 2-step process must apply. And our position is there is nothing in their brief. Investor and investment were just the 2 we showcased, but the brief, I mean, in the indirect nature of the investment, we feel that it's replete with what are obviously not jurisdictional, and they shouldn't be afforded another second round of briefing on these questions. And as an equitable matter, they've had 5 days, more than 5 days in opportunities on these issues.
Just to be sure I understand all the bidding, we've been talking about a lot of different judgments. The Swiss court on direct review or confirmation in the seat of the arbitration, they reviewed arbitrability de novo.
Yes.
The Singapore court treated the Swiss court's determination of arbitrability as issue preclusive, correct? My understanding.
It may be. On some issues,
Okay.
it did its own.
And I thought that more importantly, the Berlin court reviewed arbitrability de novo.
Yes.
Was that court wrong?
No, that's what German law requires that court to do.
So the Swiss court can review arbitrability de novo and the German court can review arbitrability de novo.
Well, yes, and in front of the German court, it was a question of Article 5.1c under the New York Convention. Was this within the scope of the agreement to arbitrate? It was a merits defense under the convention, and they are entitled to review that question de novo because it was presented as a merits defense. They of course looked at the Swiss Federal Supreme Court. They don't think the German court gave it claim preclusive effect. It analyzed the questions, analyzed the defense, and that was the framework in Singapore. It was always presented as an Article 5.1c defense. That's what Chevron and Stilex told us. That's how my colleague, Mr. Holland, in the case, that my learned colleague referred to, Marseille Klinken, presented the argument that a 5.1c defense outside the scope, which necessarily brought back an issue of immunity. But here, they raised an immunity objection. They're relying on PNID to say all we raised were colorable immunity arguments so that they get another round of briefing. And that's what we take issue with.
Well, the other argument, surely, that they make is that after things had proceeded, they discovered an investor and a company was threatening India's national security. So it wanted to act. And surely arbitration doesn't force you to continue in an agreement where your national security is at risk.
Arbitral tribunal found that was a pretext to expropriate the commercial lease, which India then subsequently leased out to a competitor. So if its national security was at stake, presumably India wouldn't have continued to use the S-band for commercial purposes. But those were issues decided by the arbitrators in the arbitration and the basis for the award of compensation.
And did they get the opportunity to have that reviewed? De novo?
They raised it before the Swiss Federal Supreme Court, the essential security interest, and the Swiss Federal Supreme Court.
So the answer is yes?
Yes.
All right.
But not before the district court.
Not before the district court. That is correct. I think they reserved it before the district court. And again, we come back to where it wrapped up before. It was everything in there's on the merits, and they shouldn't get another chance. If they wanted to raise that, they had their opportunity.
Okay, thank you, counsel. We'll
Thank you.
give Helen 3 minutes for a rebuttal.
Thank you, Your Honors. So just a few points. On colorability, I have just 4 points that I'd like to make. First is just to reiterate that there really can be no doubt in our view that our immunity arguments were colorable at the time in September 2021, a full 3 years before NextEra 2 came down. You had divergent, district court decisions. In NextEra 2, you had a 2.5-hour oral argument, 18 amicus briefs. You spent approximately 10 pages on this particular issue. There was no way that there wasn't ambiguity or uncertainty at that time. Also, as Chief Justice noted, it would create, you said a difficulty, and I would say it would become untenable if colorability was as high of a standard as DT is suggesting it would be, because foreign sovereigns indeed would feel compelled to have to brief all of their immunity and merits defenses at once in order to avoid this result in the event that the district court not only denied their motion to dismiss on immunity, but found that they really disliked the arguments so much that it would constitute a waiver. And the whole purpose of the PNID in permitting foreign sovereigns to brief immunity before the merits is to avoid the burden of litigation, of suit. So if you have to brief them all together, then you're basically doing away with that framework. Third, there was an arguable circuit split at the time, still is, with the Fifth Circuit's Al-Qarqani case that we've briefed in our papers. And finally, on that point, there is no Supreme Court jurisprudence on this. Spain has announced publicly that they are putting in a petition for certiorari. This is not a case where you have concrete circuit court precedent that has been in place for years that is being ignored by a party. Far from it. You have evolving jurisprudence and you have no Supreme Court decision. Second is that even if this court would find that our immunity defenses were not colorable, and again, for all the reasons we think they're more than colorable, then the court abused its discretion by finding that we waived our right to raise any additional merits defenses and to brief them. And we cited several cases in our briefs that I would just urge you to take into consideration, particularly the practical concepts versus Bolivia, where they say sovereigns should be enticed to appear in our courts, and we ought to give them every opportunity to make arguments. In the BG versus Argentina case, which I hesitate to raise given the history, but on this point it wasn't reversed. That's where the district court was ordered that there would be additional briefing, even though it was highly skeptical of Argentina's arguments that it had raised. And that was the language that they used. That was after the court denied Argentina's motion to vacate, and there was a cross motion to confirm, and the district court didn't rule on it. And then finally in Shatsky versus PLO, this court reversed for an abuse of discretion, finding that the sovereign had, not the sovereign, but instrumentality, or the PLO had actually reserved its jurisdictional objection and shouldn't be found to have waived it, even though it had participated.
Suppose we think the immunity defenses were colorable but wrong as immunity defenses. So I'm on the point about assignment to the arbitrator or not. Isn't there? I take your point about Indian law seeming to adopt this model of judicial review, but your friend makes a competing argument. Like, okay, there was judicial review in Switzerland. There was judicial review in Germany, which are the courts of one of the signatory countries. I mean, who the heck is DDC? This is just secondary enforcement in a country whose background rules per BG just don't presumptively recognize this model.
Well, that's also, and I take your Honor's comment about our form non arguments, but that's why also we think that this case should be heard outside of the United States. But quite apart from that, yes, and I'll leave that apart. I think that my DT's counsel's reading of the provision in the BIT doesn't accord with its text. It doesn't say what he thinks it says or what he thinks was the motivation behind it. You can't read that by the text. And I think once again, we go back to the party's intent and the fact that there was de novo review in Germany. That shows that the parties had that, or it's consistent with what I'm saying is the party's intent, because when they enter into an agreement to arbitrate with the UNCITRAL trial rules, they expect that secondary jurisdictions, as well as a primary jurisdiction, is going to have review authority. There's nothing in their as far as US law is concerned, the fact that you had de novo review at the seat does nothing to help them with a delegation argument, because the Supreme Court has said you look for clear and unmistakable evidence that the party is intended to delegate to the tribunal. Then now they're talking about delegation to the seat. There's nothing there. And there is no issue estoppel or issue preclusion in New York Convention cases. There is very limited when you see in the New York Convention.
Yeah, I don't want
You don't wanna
to
go there?
I don't want to
Okay.
get into preclusion as a basis for affirming. I'm just trying to think, can we affirm on the ground that Indian law does allow for judicial review on arbitrability, but you got that. You got that twice, and it doesn't compel every enforcement court to redo the same question.
Again, with respect, I would say no, because that's not the question. The question is, did the parties clearly and unmistakably delegate the question of arbitrability to the arbitrators? That is no. And so the fact that a court in Germany, a court in Singapore, a court in Switzerland has looked at it doesn't bear on that question. We did not delegate exclusively to the arbitrators here, and therefore the court itself, the US court, needs to look at it.
Understood. Thank you.
Thank you very much.
Thank you, counsel.
Thank you.
Thank you to both counsel. We'll take this case under submission.
Court now stands adjourned until Friday, January 17th at 9:30 a.m.